Sorry, Jane. Very well, we now continue with public business proper. The first item is the draft Public Health and Safety Rented Dwellings Licensing Jersey Regulations. The main respondent will be the Chair of the Environment, Housing and Infrastructure Scrutiny Panel. The Assembly will remember the principles were adopted on the 18th of July, and the debate therefore continues in second reading, dealing with the regulations themselves. Minister, you've launched an amendment, the 11th Amendment. Do you wish to propose the regulations as amended by the 11th Amendment?
Yes, sir, I do.
Are members content that we deal with the matter as amended by the 11th? Yes, very well.
Sir.
Sorry, yes.
Sorry, sir. I would like at this juncture to propose a reference back. The reasoning being that there is insufficient information regarding the codes of practice which are not likely to be produced until March 2024. I would therefore suggest, sir, that reference back is based, the matter is redebated once those codes of practice are published, and members will have something to vote on. At this present moment, they don't know what they're voting on. Thank you, sir.
Technically, that proposition is marginally too soon, Connetab, because I have to have opened the debate on the regulations first. But the reality of it is that all that will happen is the Minister will propose the first regulation, and then you could make the motion for a reference back. So it might be, if members agree, not to be too technical about it and permit the matter to be discussed at this juncture. I'm assuming that there's nem and con in that, so we'll deal with the reference back. Is the reference back seconded?
Yes, sir.
Yes? Very well. In which case, would you like in proposing it, I probably should have asked this first, Connetab, indicate what further information that you are seeking, or what ambiguity or inconsistency in information you are seeking to be clarified?
Yes, sir, thank you. We seem to have adopted the practice of late, sir, in passing laws with guidelines or codes of practice to follow, which tends to mean that we end up in this chamber voting for things that and we don't know what we're voting for. And my concern is principally that. And that is also the concern which has been well ventilated by those who have interests in rented dwellings, either as tenants or as landlords. So, sir, to repeat what I said earlier, I suggest that the proposition be redebated or concluded in its second and third reading once those codes of practice have been issued in March 2024, if not sooner, if so done. Thank you, sir.
So effectively, you would be looking to see the further information you're requiring as the draft of the codes of practice being having been prepared and capable of being looked at by the...
That's correct, sir.
Right. Sorry, I should now ask formally, is that proposition seconded?
Yes, sir.
Yes. Very well. Does anyone wish to speak? The debate now must be limited to the merits or otherwise of the reference back. Yes, Deputy Warden.
Thank you, sir. Thank you, sir. I'm not sure whether but it's following on what the Connetab has said. I can understand why the Minister wishes to bring more legislation regarding this topic to raise standards and weed out accommodation that falls short to what is expected in today's market, especially due to the unofficial stories from tenants who are reluctant to speak out about their unacceptable housing conditions in the fear that they may be evicted and put out onto the streets. Time passed, sir. The states were bringing codes of practice before enacting legal changes, and I cannot understand why the Minister does not do this. In my view, the Minister is putting the cart before the horse. I understand that the uprated codes of practice will not be completed, as my dear Connotab has said, till the first quarter of 24, or even later. Therefore, in the absence of these codes, then the proposition needs to be put back until we have these new codes ready for introduction. Gain more information and assess the situation, and then make any necessary legal changes. The upgraded codes of practice, in my view, will sort out the wheat from the chaff and raise standards by default and improve people's living conditions. It's my understanding, sir, that we already have the checks and balances in place under the existing 2018 law. And I believe the staff in place already to investigate premises and can apply the law. By introducing more legislation at this time, without the uprated codes of practice, in my view, and I repeat, is putting the cart before the horse, and all parties working blind. May I ask the Minister to reflect on my and my Connitab suggestion to defer this proposition until we have the requisite codes of practice up and running, so that everyone will understand what is expected, and especially the landlords and the tenants. Sir, we need to encourage people with some assurance and protection to speak out about their poor living conditions. If the premises are not up to acceptable standards, so these premises can be investigated and the Minister will be more aware of the extent of the problem. Sir, if I may quote a famous phrase, the Minister may think he's playing all the right notes, but clearly they're not in the right order. Thank you, sir.
Deputy Reynolds.
Thank you, sir. I have to say that this is the most giant red herring. The codes of practice are a significant aid that can help in assisting tenants and landlords to bring their properties to the required standard. However, they are not essential, and they have not been essential for the last 4 years. The law has been in place on minimum rented standards for 4 years. During that time, landlords have been required to meet those standards. They've been required to meet those standards without a code of practice because there are so many other avenues by which they can seek the information they need to bring their properties up to standard. They can talk to officers. They can refer, as we have suggested in many previous instances, to the UK guidelines, which give a good first approximation of the kind of standards they should be aiming for. And we have actually, as a department, put on events to help. There's been a breakfast bites session. There's some special training offered to JLA members. There's also been a particular document produced with advice on mould. So there have been documents produced to help. But this is all part of a process. It is not something that begins and ends with a code of practice. The laws are in place. The ability of a landlord to meet the standards in those laws is not impeded by the lack of a code of practice. The code of practice is certainly going to be helpful when it comes out, and I have guaranteed that it will come out by the end of March and in all likelihood well before then to help assist. But it is not true to say that it is necessary for the functioning of these regulations, in the same way as it's not true to say it's been necessary for the last 4 years for the functioning of the primary law. The other point I would make is that this seems to hinge on the idea that the regulations will come into place, licensing will come into place, and landlords will be under immediate threat of their license being withdrawn and then they'll be unable to run their business. That is not the case. The point of this law, the point of licensing is almost the exact opposite. It is to put in place a flexible system of dealing with poor rented standards. It is to replace the current system, which offers just one option in the case of non-compliance with minimum standards. One option currently available, which is criminal prosecution. That is a sledgehammer to crack a nut in many cases. Criminal prosecution sets a very high bar. The point of licensing is not that should a landlord fail to meet one of the minimum standards, that the license should be withdrawn. The point is, as specifically outlined, and we'll get onto this, I hope, when we start talking about the regulations in detail, the point is for landlords to be able to be given a condition on the license which asks them to take action in order to rectify the problem. It is a graduated response, a flexible response. That is the reality of what we are proposing. So it is not the case that the code of practice is necessary before this comes into place, because the standards have already been in place without that code for a good many years. And it is also not the case that the great fear that is hung around this, that without clarity around that code of practice, landlords will face having their license withdrawn and being unable to operate. That is also not the case, because that is not how licensing is designed to operate, and you only have to look at the regulations to see that. Licenses can be made conditional upon rectifying faults. Obviously, some of those faults will be more serious than others. Only in the case of complete uninhabitable properties would a license be withdrawn. That is very rare, and in those circumstances, I suggest to members that it would be fairly evident, without a code of practice, that those conditions had been met to withdraw the license. So no, I think this is an attempt to stall the aircraft on the runway. It's totally unnecessary, and we should get on and debate the merits of these regulations, bring in the code of practice in good time, well in advance of the regulations coming into force, and let's have the debate now. Thank you, sir.
Very much. Colin Talbot, St Mary.
Thank you, sir. Perhaps I could begin by saying I speak as a private member, not as a member of the scrutiny panel. And I'm pleased to hear the words of reassurance from the minutes. But it does beg the question as to why, as we're dealing with the codes of practice for a 2018 law, there's been so much reluctance to produce them. And that is the problem. That is what the landlords essentially, who are probably laymen in these matters, fail to understand. There was reference at a public hearing to codes of practice being brought in beforehand. That was certainly interpreted by some landlords, meaning before the main debate took place. I accept that it is open to interpretation. The Minister clearly meant before the licence regulations came into place. But I do go back to the fact and emphasise the fact that the codes of practice we're talking about are not the codes of practice solely relating to the regulations we're about to debate. Yes, there are some forms to be determined and that would be useful to have there, but these are the codes of practice in the 2018 law. And if I may, sir, I may just quote the beginning of Article 4. The Minister may, and I appreciate it may, after consultation with such personal bodies as appear to the Minister to be representative of the interests concerned, A, prepare and issue codes of practice for the purpose of providing practical guidance, etc., and revise it. Then he goes on, subparagraph 3, a failure on the part of any person to follow any guidance contained in a code issued under this article should not of itself render that person liable to proceedings of any kind, but any such code shall be admissible in evidence in criminal proceedings, and if any provision of the code appears to be the court conducting any proceedings to be relevant to any question, etc., it shall be taken into account. And the point I'm making, sir, is that it was felt sufficiently important to emphasise in the law that, yes, it could be relevant to criminal prosecutions. And in that context, I yes, it's hardly surprising that landlords are concerned to see some codes of practice. And I do go back to the point. In scrutiny, we did ask when these are going to be made available and whether it's in March or beforehand. I do not understand why these are not being made available before now. And given that it need not affect there's a delayed start to the licence requirements, I do not see the principal objection to delaying the implementation until those codes of practice have been produced. So it's not a scrutiny matter, but I do support the proposing, agreeing that we should defer till the codes of practice are in print. Thank you, sir.
Deputy Scott.
Thank you, sir. I find it, when the Minister has just spoken about a red herring, and I'm not sure who's doling out the red herring. I feel there may be an inconsistency in his approach here, because earlier we heard the Minister say, you don't need to be debating this proposition of Deputy Balash's what's the rush, and now we're kind of like being told, well, the Minister wants to rush this through despite there not being codes of conduct in place. And so what is the rush? And when I think about this, I understand, I've actually seen descriptions of some really quite, not pleasant sounding rental properties. We know that they are out there. We know that they need to be addressed. And I believe that the original argument was that, well, we'd like to do something about this, but we can't do random inspections. But we then had advice that the department could do random inspections. And then we were told that the problem is that the officers didn't know where the properties were. And yet I'm thinking, heavens, if these officers were anything like the IRS, they'd probably be going around looking at posts on Facebook and things like I might do and think, oh, there's probably an inquiry to follow up here. There's, and then there's this concern, people might think that the landlords, that a landlord might be punitive against the tenant because they will think it's the tenant who's complained to the department. And that could happen in any circumstance. So I do find the thinking all around this has been incredibly confusing. And then we come back down to, but could there be revenge evictions, and does this really solve this? It would, if we could just strip it away and look at that could be useful. What is the, I share the Constable Johnson's discomfort about penalising people without being clear about definitions. I think, how long does it take to produce a code of conduct? I'm sympathetic towards this proposition. I do believe that there are just these questions that I find I can't comfortably go forward at this point.
Does any other member wish to speak on this proposition? Deputy Luce.
Thank you, sir, and I hope members will bear with me. I'm a little bit surprised that this has come forward. We discussed it, and members will know that we're not happy about the situation, but certainly my panel weren't going to refer this back immediately. But I would just say to members, sir, that the feedback that my panel received explained that there is a significant uncertainty with how the licensing scheme is going to be operated and enforced in practice, and that it's not ideal that this Assembly is debating potentially adopting the draft regulations without any published guidance. Our advisors that we engaged from the UK, a company called Justice for Tenants UK, pointed out that under the draft regulations, standard licence condition information to occupiers could lead to a vast difference in the content and quality of the information provided from landlords to occupiers, and they went on to say how they thought that could be improved. The panel, and I know we're not talking about the toolkit here particularly, but there will also be alongside the Code of Conduct a toolkit of pro forma wording and templates that we're going to need to be provided by government to landlords. And again, we ask that this could be brought forward. There should be a clear process for officers to follow to ensure equal treatment of offenders, along with standardised templates in respect to warning letters and formal letters relating to legal proceedings. Now, sir, as you might have expected, the scrutiny panel did question the Minister at length about the Code of Conduct, and we pressed the Minister on when this Code of Practice, Code of Conduct, would be published and we were advised that it was being worked on. And the Minister said, I asked for it to come in time for when the legislation was originally going to come in, which would have been in the new year. So the Code of Practice would have been ready in November. I think we had it scheduled for the end of November. And I think, sir, that's interesting because the fact that this debate was delayed by scrutiny calling it in means the Minister immediately must have put this work onto the back burner. It was scheduled to be finished for the end of November, and it's now scheduled not to be finished to the end of March, and that is curious. In our comments, sir, the panel have made some recommendations where we weren't able to bring forward amendments because we consider it would have been beneficial for a code of practice to have been published prior to the lodging and the draft regulation so that private landlords, social landlords and industries with worker accommodation could better understand how the law will be applied to them. And our recommendation, which one of a number of recommendations in our comments paper presented on the 26th of October, was that the Minister should publish a code of practice containing guidelines of how the law and proposed regulations will be applied in practice. In addition, a landlord toolkit should accompany the code of practice containing pro forma templates of relevant documentation that landlords will be expected to provide to occupiers before the end of February. So, sir, the proposition has been made for a reference back. Certainly, scrutiny would be very interested in looking at the code and how we could improve it further if at all that's at all possible. But I say to members, we weren't happy about this. It wasn't part of an amendment, but certainly it's something which has been highlighted to us on a number of occasions. Thank you, sir.
Thank you, Deputy. Deputy Coles.
Thank you, sir. I think just following on from Deputy Luce's comments there, obviously about the work maybe being put onto the back burner, the first thing that came to my mind was would we waste officers' time for something that, if it gets rejected, might not be required? So maybe that's the reason for that being delayed further and further down the road. My also thoughts is I wonder how many members here have had to write a code of practice themselves, because I have. When GDPR became law, we had to change the process by which we worked for my previous employer, which meant that I had to write a rule book for how my staff carried out their duties to make sure that we complied not only with GDPR, but with client audits. Clients had to provide us with their requirements first. So in this instance, I can describe that as almost the regulations by which will be passed, with this assembly passed in 2018. You then have to start putting these into practice and finding out who your customers are, which might be in the case of how you'd look at the licensing. But when you start writing codes of practice, guidelines, however you want to call them, you do about 4,000 iterations before you get to something that you're comfortable with. You have to find what's working, what doesn't work. You want not only examples of things which are good practice, because you want to demonstrate those, you have to find the things which are bad practice. You have to gain your evidence. So actually, by having the debate now about bringing in the license, allows the department more data to find some examples of bad practice that they could put into their guidelines, as well as the good practice that everybody should be out there trying to follow and emulate. So I think in kicking this into the long grass again makes everything, delays everything, and we don't get all the data that we need to produce a decent set of guidelines that our landlords can follow, as well as the tenants know where their position are. So I say let's get this debate on with and go from there.
Deputy Rob Ward.
Thank you, sir. So many iterations of this have come forward, and we've had the principles accepted before and then regulations rejected. And I was going to make some comment about, I thought we were back in the fishing debate because of the number of red herrings flying around, but that was taken away. What's happened here is a classic straw man argument. We're going to create a huge issue from something that was not a huge issue before, but it was identified, a set of non-statutory codes of practice, which are codes of practice that relate to the legislation as it comes forwards and the law that already exists about the standard of homes. We're going to take that small issue, we're going to turn it into something so big that it prevents this happening. It is a simple tactic to prevent this happening. That is what's happening. And it's happening because of the pressure that's been put on individuals to bring this forward. Now, we have to make decisions in this assembly. It's about time we made a decision on this piece of work. We've been here too long. And why? Talking about rushing it, it's not rushed. We've been here for years. But why does it need to be rushed? Because there may well be, and there are, children living in inappropriate accommodation on this island whose health are being affected. Whose health is being affected, sorry, sir. There are people living in inadequate accommodation, and this licensing is the softest touch you can possibly have to address those issues. And I think that point that was made by the Minister, and I don't always agree with, I use the word always, I don't know what words to put in there actually, agree with the Minister. I don't frequently agree with the Minister. But the point he made regards, I've lost my point now, sir, because I was trying to think of separate words. There was an issue made around why this legislation is needed in terms of it's a simpler way, a more accessible way to deal with inadequate accommodation, i.e. it doesn't go immediately to the criminal law. And let's think about that, because that's where we are at the moment. And that is why this is so necessary. The code of conduct has no real impact on that. And I think some of the things that were said about, well, if you look back to a 2018 code of conduct, it was quite important as to look at giving evidence and so on and so forth. Of course it is. Anything around the law which is going to be implemented to say we will ensure that in Jersey, the homes that people live in reach a standard, and you will be licensed to do that because it is important for the well-being of the people living in those homes. And good landlords who provide decent homes no longer have to compete with those who do not, and there's nothing to stop them doing that apart from this draconian way of going to the criminal court to do something about it. And that's the issue that we've got here. And what we've introduced here is just another way to delay, another way to kick this into the long grass and get nowhere. And I plead with members, don't accept this. The code of conduct will come. If the code of conduct is inappropriate, it can be changed. And let's be honest about it, any code of conduct can be changed. It's a code of conduct. You can change your code. We can change our own code of conduct if we want to. And so that is not, the argument that is being used here, I believe, is misplaced and misdirected for the wrong reasons. So let's have the debate. I say to members, if you don't want this to happen, vote on that when we debate it. Put your vote into the pad when you vote to say, no, I do not believe that we should license landlords in this way because I don't think they need to be, and stick by that. But stop putting obstacles in the way, simply delay, and let's have this debate in place now. There were 11 amendments from the scrutiny panel. Not one of them was the amendment around the code of conduct. Suddenly this has appeared and become a huge issue and blown up and blown up and blown up. And now all of a sudden, at the last moment, although there seem to be a lot of prepared speeches to talk about this, there's suddenly a reference back. We can't continue to have that cynical approach in this assembly to passing legislation and debate. Let's get on with the debate. Let's get on with talking about it and decide once and for all, because we've been here so many times that we cannot kick it into the long grass any longer. There will be a problem with the code of conduct when it comes back. It will be delayed again. There will always be a reason to delay it because we're not willing to actually stand up and make the decision here and now. So let's not delay this. Let's get on with the debate and let's get it out of the way and let's make a decision. And I hope we will therefore improve the standards for people, approve the assurances for people who are living. Good landlords have nothing to worry about. Those landlords who are not meeting standards have got an opportunity to meet those standards with the support of a department, and we improve housing on this island. Let's not kick it into the long grass. Thank you, sir.
Much, Deputy. Deputy Jean.
Thank you, sir. The code of practice needs to be relevant. And first of all, the Minister told us about the fact that the code of practice for the UK is being used as the baseline for code of practice that's happening now with the law that's been running for the last 4 years. And the UK is actually revising their code of practice at the moment. So it's important that we develop our code of practice in, as the UK is revising. And so we need to have an update and relevant for the moment. And that comes to the second point with, as Deputy Ward just mentioned, we are about to debate quite a substantial amount of potential changes that could be to this regulation and to the schedule. And the schedule details those kind of things that will need to be in the code of practice. And therefore, we should probably have the debate first to understand what this assembly wants to have as details within the schedule, within the regulation, and then be able to develop a code of practice accordingly. To have a code of practice first is putting the cart before the horse, because it would have to be changed depending on how the assembly decides on what this regulations and details within the regulation would be. Thank you, sir.
Deputy Chief Minister.
Sir, I think, could you, I'll speak later if that's possible.
Well, if you're indicating you don't wish to speak now, Chief Minister, that's
No,
fine.
thank you, sir. Sorry, I hadn't realised you'd seen my light.
Deputy Balash.
So the Assembly will be aware of my position on this, but I will say that if the regulations are to be passed, we ought to ensure that the rules and regulations are in as good a state as they can possibly be, given that we are interfering substantially in the freedom of an individual to rent out his or her own property. It is true, as the Minister says, that the law has operated without any standards being in place for 4 years. But the difference is that now we are to have a system whereby the owners of property can be refused permission to rent out their property for any of a number of reasons. The Minister should want to enable landlords to be absolutely clear as to what their duties are. Deputy Ward reminds us that people are living in inadequate conditions, and I am sure that that is so, but he is wrong to state, and the Minister is wrong to state, that the only remedy is through the criminal courts. There are civil powers available to compel bad landlords to put their premises in good order, and it is incomprehensible to me as to why the authorities decline to use these powers. I think that the standards should be put into the public domain so that members can look at them before we take the final step of interfering with people's liberty in the way in which it is proposed. And indeed, I would go further. I would like to see the Minister put the application form, which is to be completed by landlords applying to rent out property, into the public domain so that people can see what it is that they are going to have to fill in. Why can't we see it? The Minister should be more transparent. It's part of his government's policy. And if he were more transparent, I think he would find that many of these obstacles would simply melt away.
Deputy Mezek.
Sir, if he were to be more transparent, I'm pretty sure some more obstacles would be found in the place of these ones, because we've been here before and it's exactly what has happened every time these proposals are brought to the States. One set of objections are raised, whoever the minister is at the time addresses those objections, and lo and behold, a new set of objections arise. And this, of course, is the most recent one. It was interesting when Deputy Balash said early on in his speech about needing to know what the rules and regulations were before going ahead with this. Sir, it is the regulations that we're debating today. They are published, they're in front of us, and that is what we're debating. So there is no reference in the draft regulations to a code of practice. It is not a statutory item. It's supplementary to that, and itself as a document will not hold any legal standing. It's the regulations themselves that provide the legal basis for this scheme. And so what that actually theoretically means is a code of practice can be produced in advance of debating these regulations, if that's what the Assembly decided it wanted the Minister to do. But because that code of practice has no legal standing, the Minister could amend it the day after. He could do something totally different with it. As a document, it doesn't have the standing that the 2018 law and these proposed regulations have. If you wanted an abridged code of practice, it would say, obey the law. Because we've had this law in place on minimum standards for since 2018, there is no excuse at this point for people who run the business of renting out property not knowing what those standards are. And we have an environmental health department who, on a matter of principle, since those minimum standards were introduced, have had an approach that is soft to landlords if a problem is discovered. It is not one of handcuffing them right away and taking them to court and prosecuting them. It's one of sitting down with them, working out what the issue is and trying to work through it. And that's one of the reasons why there have been, I believe there have been no prosecutions under this since that was introduced, and the Minister's nodding to confirm that. That's the approach that's been adopted, and there is no excuse 5 years later for not understanding all of that. What the Code of Practice, which the Minister has said he will produce, is to provide a little bit more clarity on the practicals. Those practicals will be, however the Department and the Minister choose to implement in practice these regulations, but they don't at all change the minimum standards that will be required, that are required for landlords to maintain their properties. That will remain exactly the same. And if there's an issue with the Code of Practice itself, there will be no legal route of appeal on those, because it's a purely voluntary document that the Minister is offering to try to be helpful. I would say he's bending over backwards, actually, to accommodate what has already been the law for 5 years. This is a red herring. It is not normally the case that when regulations are proposed in this Assembly and an external reference is made to some other document, that the Assembly is required to give its approval to that document at the same time as the regulations. That is not a requirement, and there's nothing in the regulations themselves saying that there is to be a code of practice that will have any kind of legal standing outside of it. It's purely voluntary, the basis upon which that is being done. So, sir, if members are against the principle of these regulations to require a licensing regime which is proactive and which means that landlords will not be able to rent out properties until they have those licenses and can demonstrate that they meet the minimum standards that have already been law for 5 years, then members are perfectly within their rights to vote against it. We've been there before. That's why we don't currently have a licensing regime. It was brought several times previously and voted against, and if that's the will of the Assembly, then so be it. That will be how we'll have to proceed, and that will be the democratic outcome. But, sir, there is nothing that can be revealed in a Code of Practice publication that will change anyone's mind on that principle. I think members have probably worked out where they stand on that principle. So rather than waste further time on this, we should just decide today whether or not we want this regime. A Code of Practice has no standing and will not inform that debate at all.
Does any other member wish to speak on the proposition for a reference back? No other member wishes to speak? Then I close the debate and call upon the Connétable to respond.
Thank you, sir. I would first of all assure members that this is no red herring, but the intention is to make the law a good law, which at present I don't believe it is. And with I've been involved with the scrutiny panel, which has arrived at the point of submitting 11 amendments, and I don't believe so. That indicates that the original proposition was good in the first place. And time again, and I refer to the last speaker, I have sat through, I think this is the third debate on this particular law, which keeps coming back in various guises, but still doesn't seem to be satisfactory. For my part, sir, the last thing I want to do is condone poor standards of accommodation, and I don't think anybody does. But we have to get this right. We can't put landlords in a position whereby they risk criminal prosecution without being aware of the reasons why that might be levied. That is completely unfair and unreasonable. And that is the point of my reference back, sir, just to ensure that those involved are completely 100% clear as to what regulations they have to comply with, and do that with the ability to sleep at night without the risk of a sword of Damocles hanging over them. Thank you, sir. And I make the proposition.
Do you call for the appel, or?
Yes, sir.
Appel is called for. I invite members to return to their seats. The vote is on whether or not there should be a reference back in connection with this proposition. The reference back is so that when the matter comes back, it will come back with the codes of practice or conduct, as the case may be. If members have returned to their seats, I ask the greffier to open the voting and members to vote in the usual way. Members have had the opportunity of casting their vote, and I ask the greffier to close the voting. The proposition has been defeated. 18 votes for, 26 votes contra, no abstentions.
Can we have the 18, please?
Those voting for the Connotabs of St Brelard, Trinity, St Peter, St Martin, St John, St Clement, Grouville, St Juan, St Mary and St Saviour. Deputies Luce, Lehegara, Balash, Scott, Rose Binet, Howell, Tom Binet and Barbara Ward.
We then proceed with the debate, and Minister, there are two amendments to the 11th Amendment, both lodged by the Environment, Housing Infrastructure Scrutiny Panel. They both relate to Regulation 2, so we'll need to address them at the point that we reach Regulation 2. Do you therefore wish to propose Regulation 1?
Yes, sir, I do. So, Regulation 1 is as amended by Amendment 11, is a relatively simple regulation that sets out the definitions of what constitutes a licence and defines the process for making an application. It has been amended by Amendment 11 to be more specific about the definition of a licence, and in particular to make clear that the licence remains in force even if it is modified as a result of a condition that may have been imposed following an inspection. It has also been amended to provide much greater precision about what defines a valid application. I believe these changes respond to Scrutiny's desire to provide greater clarity within the regulations about when a valid application has been submitted. So I've been happy to accept those amendments, the amendments that were suggested by Scrutiny, incorporate them into Amendment 11, and as such I'm happy to propose Regulation 1 for the Assembly's approval.
Is Regulation 1 seconded? Yes, sir. Does any member wish to speak on Regulation 1? Those in favour of adopting Regulation 1 kindly show. Those against? Regulation 1 has been adopted. We now move to Regulation 2. Do you wish to propose Regulation 2?
Yes, sir, as amended by Amendment 11.
And is that seconded? Yes, sir. We then come to the first of the amendments from the Environment, Housing and Scrutiny Panel, and I ask the greffier to read the amendment.
Page 2, substituted Regulation 2, delete substituted Regulation 2, brackets 2A, and renumber the subsequent subparagraphs accordingly.
Deputies.
Thank you, sir. I'm not going to go on at length to members about the history of the last few months, but certainly my panel called us in to have a look and realised there was quite a few things we needed to do, culminated in 9 amendments coming forward, and I'm grateful for the Minister for working with us to get the vast majority of those into the 11th amendment that we now have. But there are still 2 outstanding issues, so they're quite simple and straightforward. And the first one is an amendment, and the aim of this is a proposed amendment is to bring lodging houses within the scope of the proposed licensing scheme that we're talking about today. Now, the Minister has rejected our amendment on the basis that he considers it would be a duplication that's already covered under a separate regime. But the panel challenged this, and we're asking the Minister, and I would ask the Minister to outline in his speech to this why he considers it satisfactory to have 2 separate schemes, and why a repeal of the Lodging House Registration Jersey Law 1962 could not have been proposed to the Assembly in tandem with this legislation, so that lodging houses could have been bought under the same licensing regime right from the start. And I would stress to members today that the work that my panel have done on the amendments is at all times tried to make things better, tried to make things simpler, and tried where we can to get everything in one place. And this proposed amendment would bring lodging houses into that same place as everything else. The aim of this proposed amendment is just, as I said, to bring lodging houses into the scope. Several stakeholders independently expressed their views to the panel that lodging houses should be included under the proposed licensing regulations, particularly as these properties are viewed to be at the higher end of risk for health and safety and more likely to house vulnerable people. The Public Health and Safety Rented Dwellings Law 2018 includes provision for lodging houses to be included. However, as currently proposed, Regulation 2.4 of the draft regulations excludes them. If Regulation 4.2a were deleted, as proposed by this amendment that I bring now, they would come within the scope of the proposed licensing regime. My panel understands that lodging houses are regulated under the Lodging House Registration Jersey Law 62 and are registered on an annual basis with fees charged at £15 per person. Furthermore, inspections, we understand, are risk-based, meaning that inspections are targeted where they are suspected to be problems or if a complaint is made to the Environmental Health Department. And this is important, sir. I want members to be quite aware, not every individual lodging house is inspected on an annual basis. In a written submission, Justice for Tenants, as I've mentioned them before, they were our UK advisors, they commented as following: lodging houses do not need currently to have a licence. This is curious, as they constitute some of the cheapest rental accommodation and are likely to be at higher risk of substandard conditions and average rented properties. Indeed, the first set of private rented sector properties to require a mandatory licensing scheme in England, large houses of multiple occupancy, predominantly in a way to decrease the instances of fire caused by poor maintenance and management, including unsafe gas and electrics. And it's hard to see why a high-risk property should be exempt from the licensing requirements that we're debating today. In the absence of a strong argument for why lodging house dwellings should be dealt with under separate legislation, my panel very clearly takes the view that they should be brought under the same legislation as other rented dwellings, and therefore we propose this amendment to the draft regulations. Thank you, sir.
Is the amendment seconded?
So may I just, I'm not sure if there should be declarations of interest. Now we're onto the regulations, but I wonder if...
Well, I think the declarations of interest were already dealt with, weren't they, when the principles were dealt with, and I am assuming that the same declarations obtain here.
Okay, so I thought so. I just thought I'd mention it in case there were any others.
What did I tell you?
Can I just say on that front, sir, I've got one less interest than I had before, so and I think I'm not saying that I'm losing interest by the day, sir. I was in my own capacity, a quarter landlord of the family home, and that's no longer the case. It's not rented out, but my wife is still a landlord. So it's a slight change from the last time, so probably worth putting on the record.
But presumably you weren't disqualified on the last occasion and you voted, and it seems your right to vote is even more enhanced at the moment.
Thanks, and I'll be supporting the legislation.
Very well. Deputy Rose.
Thank you, sir. I hope I can clarify this, because it's a strange one, because it seems so obvious, and yet actually it isn't the case that I can support this. I do want to ask members to reject this amendment, and that's for the simple reason that it isn't necessary. And passing it would effectively create a form of double regulation for lodging houses that I think would be wrong in principle and would place an undesirable additional burden on the lodging house sector. The stated intent of this amendment is to bring lodging houses within the scope of the licensing regulations proposed in P40, and it does that by removing the specific exclusion that for lodging houses that is found in Part 2, Section 2A of the regulations. It sounds sensible on the surface because, of course, as Deputy Luce has said, residents of lodging houses should not be excluded from the protections that tenants in other rented dwellings will enjoy. However, the reason I would urge members to reject this amendment is that lodging houses are already covered by a scheme that has the same practical effect as these regulations would have. Therefore, making lodging houses subject to the licensing requirements would duplicate an already existing legal framework. I'll come to the point of whether we should abandon that lodging house law in a moment, because I don't think that's the answer either. If I set out the legal position, first of all, it's absolutely clear that lodging houses are within the scope of the 2018 Safety of Rented Dwellings law. That is the primary law under which the regulations in P40 have been lodged. They are rented dwellings, therefore they must reach or exceed the safety standards established in the 2018 law. So if they are within the scope of the primary law, why should they not be covered by the regulations in P40? And the answer is found in the 1962 Lodging House Law. This law creates a scheme that in many respects is virtually identical to the proposed regulations within P40. The Lodging House Law creates a requirement on lodging house operators to register, makes it an offence to operate a lodging house without registering, and crucially gives the Minister, which in this case is the Minister for Housing because it's his law, the ability to withdraw their registration if they are found to be in breach of relevant requirements. So those are essentially, although they call it a registration scheme, it is essentially a licensing scheme because it is not just telling you something, which is what a registration scheme does. A licensing scheme is requesting permission. And that registration scheme functions, even though it's called a registration scheme, it functions exactly the same as a licensing scheme. There are other similarities between the 1962 lodging house rules and the regulations under debate today. Just as in the regulations I am proposing, lodging house owners or operators can have their registration subject to conditions, for example, to improve their property. Lodging houses can be inspected, as Deputy Luce pointed out, just as rented dwellings can be inspected under the regulations in P40, and just as we will be doing under P40, that would be a risk-based assessment inspection. Lodging house certificates must be displayed in the lodging house in the same way that the regulations proposed in P40 will require a landlord to make available the licence for a property for inspection by a tenant. And in extreme circumstances, as already noted, registration of a lodging house can be withdrawn, just as it will be possible in the most extreme circumstances to withdraw the licence of a rented dwelling. There's one further point to make. If a lodging house ceases to function as a lodging house and becomes a rented dwelling, it will automatically fall within the scope of the regulations I'm proposing. The landlord will then require a licence to operate a rented dwelling, just as every other landlord does. So there's no way around the licensing requirement if a property had previously been a lodging house. Now, Deputy Luce has raised the possibility of why, if we have two laws, why do we not get rid of the lodging house law and simplify everything? And the answer is that that may well be a medium-term possibility, but in the short term, it would create very considerable difficulties, because in repealing the 1962 law, we would lose a whole series of things which are not covered by these regulations, and therefore we would then put the lodging houses into a position where there were several things which were no longer regulated that we would want to regulate. So those are additional clauses in the lodging house laws that are not replicated in these regulations, and therefore we would lose those extra and important controls over lodging houses if the 1962 law were repealed. These would include the loss of the definition of a lodging house, the loss of the power to refuse a registration, for example, if the applicant is not fit and proper. That is a rule within lodging houses that it does not apply to rented dwellings, because rented dwellings are judged on a different category, and the right and proper test is not necessary. The other reasons why the other reasons why a registration might be refused for a lodging house include if the use of the premises is causing neighbourhood annoyance, or the loss of the requirement to keep a register of occupants. These are things which are specific to lodging houses, and therefore there is a lodging house law. As I say, in the medium term, we might want to think about how those could be brought together. But for the time being, simply repealing the 1962 law is not an option. So all these things are not covered in the regulations for rented dwellings and would therefore be lost if we were to repeal the lodging house law. So to summarise, my position is this. Lodging houses are already within the scope of the 2018 law and must meet the standards contained therein. However, the purpose of these regulations is to provide a flexible and efficient means of enforcing those standards, and lodging houses already have such a scheme in place. Enforcement tools already exist in the 1962 law. Therefore, it would be unfair and wrong for lodging house owners to have to apply for a registration certificate by the 1962 law and a licence via the regulations in P40. It would impose an additional, unnecessary, bureaucratic load, duplicating to a very large extent information and actions that are already required. I do understand where this amendment is coming from, and I do think in the medium term we should look at how we could bring these things together, but I urge members to reject it as unnecessary and unfair given the situation we're in now. Thank you.
Deputy Scott.
So the Minister said that what scrutiny suggested sounded sensible, and then went on to suggest it wasn't, but actually it does sound sensible, that there is a whole approach I can see towards policy making and legislation making, which is absolutely, how can I say, the impact on the people who have to apply and go through what is basically a lack of joined-up thinking, a shying away of just simply grabbing the bull by the horns and saying, we can't have all these different laws and this. Why don't we overhaul the lot of it and just have something that is simple, easy to administer? The landlords are providing a service. They are a business, and like so many businesses in the island, they are actually just getting more and more red tape. I mean, I think this is a sensible suggestion by scrutiny, but frankly, if the Minister isn't going to repeal the lodgings law, how can I actually say, oh yeah, you know, let's have lodging houses subject to two separate laws? So, you know, at this point, I feel that my hands are sort of tied. But I am totally disgusted by the way we continue in this fashion, just making things more and more complicated and muddled, rather than just giving people a break just to clear the fog and the smoke a bit so that they can operate efficiently for the good of the whole community. I just say, Minister, please stop barging into these things rather than taking us down roads which aren't particularly well thought out and basically tie our hands when what we're really doing is actually suffocating our community with more and more red tape.
Deputy Mayor.
Thank you, sir. The Minister is advocating keeping things the same for lodging houses, so actually that means less confusion and less disruption for them. So those previous comments make no sense whatsoever. Sir, the reason that I oppose this amendment, even though on the face of it, it does sound logical. Of course it does, to have one law instead of two, and in an ideal world that would make perfect sense. And perhaps that is a long-term option. Perhaps it is. But in the short term, sir, it doesn't strike me as worth supporting, because if the rest of these regulations are adopted, we are about to introduce a new regime affecting the other types of accommodation, rental accommodation, rather than lodging houses. That will be a new system that will need to be put into place and everybody gets ready for it. You then want to throw lodging houses into it at the same time to solve what problem exactly? The status quo is okay. Okay, maybe there are improvements that could be made at some point in the future, but to take them out of a regime which currently exists and which everybody knows how it works and which has been going for a while, and to put them in a new regime which hasn't yet been established, doesn't actually fix any problem. It doesn't help. It doesn't help improve how those are regulated. So perhaps it's an option in the long term, but right at this moment in time, I would suggest members vote against it. And if it needs to be revisited in the future, that's the time to do it.
Thank you, sir. The motivation behind this amendment was actually to simplify what is a complex situation, hidebound in red tape. I would suggest, sir, that given the Minister now has time to review his guidelines, which will be produced in March 24, maybe that's the time to incorporate any changes which may pertain to lodging houses and cover that off at the same time. This is purely an amendment, as I say, to simplify the present situation and make it more easily understandable by those members of society who are involved with lodging houses. Thank you, sir.
Does any other member wish to speak on this amendment? Deputy Robert.
So just very briefly, the thing that has interested me, convinced me, is part 6 of the lodging house law that says we're not, Minister is of the opinion here, but applicant is not a fit person to keep a lodging house. I stood up when we talked about rent-a-room in this assembly, and I still raise that concern. There is a huge lack of safeguarding in that rent-a-room scheme. I think it was a very, very bad idea. But we have a rule, we have a law here that exists and seems to be working to say you've got to be a fit and proper person because of the nature of the accommodation, which I think is intrinsically quite different from the landlord licensing scheme as we'll go forward on accommodation of that form. Therefore, at this stage, I see no reason to incorporate the two because we could be losing something that's useful. In the long term, I do feel that would be appropriate to do that, but you're going to have to look at that section of that law. It's section 6, subsection 2A, that I think would be important to see how you don't lose that, because it is a protection in a lodging house, which is a different form of accommodation. And also, sir, maybe people perhaps with less rights who are living here temporarily or they just arrived, and so there needs to be some protections down, and I would not want to lose that. So that's the specific reason why I won't be voting for this amendment, and I hope members can consider that. Thank you.
Does any other member wish to speak on this amendment? No other member wishes to speak? Then I close the debate and call on Deputy Luce to respond.
Thank you, sir, and I won't take long. As my Vice Chairman has already said, the intention of this amendment is to keep things simple, to get everything into one place so that it was straightforward and much easier for both landlords and tenants to see exactly where they were. The Minister was at pains to tell us for quite some time how everything's exactly the same, and he did point out right at the end of his speech the few things that are different that he'd like to keep. And in different extra standards and requirements could be imposed on these new regulations at a later date. There's no reason why it couldn't be included in legislative amendments. The licences and the fees would be the same. There would just be a few tweaks needed to bring these lodging houses in. I can't really say more, so the scrutiny panel made really big effort to try to keep things simple, to get everything in one place so it's easy to see where we are. We accept that we may need to make a few more tweaks to get lodging houses into this, but we think it's really important to have all rented accommodation in the same place here, and I propose this amendment, sir.
Is the appel called for?
Yes, please, sir.
That is called for. I invite members to return to their seats. The vote is on the First Amendment to the 11th Amendment. And I ask the greffier to open the voting. If members have had the opportunity of casting their vote, then I ask the greffier to close the voting. The amendment has been defeated. 12 votes pour, 35 votes contre, no abstentions.
We have the 12, please.
Those voting for the Conotubs of St Brelard, Trinity, St Martin, St John, St Juan, St Mary and St Saviour, Deputy Labby, Luce, Lehegara, Rose Binet and Barbara Ward.
Very well, we come to the second of the amendments from the Environment, Housing and Scrutiny Panel, and I ask the greffier to read that second amendment.
Page 2, substituted regulation 2. After substituted regulation 2 brackets 4, insert 5. The Minister must not impose fees if the dwelling to which the application relates is owned by A. Landium Homes, B. Christians Together in Jersey Housing Trust, C. Claude de Paradis Housing Trust, D. FB Cottages Housing Trust, E. Jersey Homes Trust, or F. Lebeau Housing Trust.
Deputy.
Thank you, sir. And again, this is quite a simple and straightforward amendment. The aim of it is to amend the draft regulations to require social housing providers to obtain a licence under the proposed licensing regime. But the important part of the amendment is this, sir, to exempt them from the associated licensing fee. In views expressed to the panel, this is the scrutiny panel, social housing providers questioned the necessity for their inclusion in the proposed licensing regime altogether. They've also shared their concerns with the panel around the potential impact of a licence fee and the costs. And a very brief summary of what they, the concerns they had might go as follows, sir. The social landlord said that the government already know where social housing properties are. They know that social housing providers keep their homes up to UK decent home standards and carry out regular inspections. They know that if there's an issue with the condition of a social housing property, that provisions already in place within the Public Health Rented Dwellings Jersey law for tenants to complain. They know that for the introduction of a licensing scheme, if it's to prevent revenge evictions from occurring by enabling government to know where rental properties are so that random inspections can be made on the property within, while the tenant has been left concerned that a complaint made to environmental health will result in a revenge eviction. They know that exempting social housing providers from a licence scheme does not mean that they will be exempt from having to comply with minimum standards. And whilst the Minister's argument that the currently proposed cost of a licensing scheme is sufficiently small at £60 every 2 years, it will not impact negatively by being included in rent. There is a risk that this fee could rise disproportionately in the future should operating costs increase. And furthermore, Landium Homes, who members will know have a rental increase policy which caps at 4%, regardless of where RPI is, Therefore, that may leave them with little additional scope to add the cost of the licence fee to rent. So this is quite straightforward. It's about asking whether we want our social housing providers to also pay a charge for their licence. We agree that they should be licensed, but having reviewed cases put forward from both the Minister and the providers themselves, the panel is of the view that social housing should be required, social housing providers should be required to obtain a licence. However, considering their status as a non-profit organisations, the panel believes the case has been satisfactorily made that they should be exempt from a licence fee, and therefore proposes this amendment, sir.
Is the amendment seconded? Yes, sir. Deputy Taddy.
Thank you, sir. This might sound tempting on the face of it, but I really don't understand the logic. And I think there are at least a couple of compelling reasons why we shouldn't exempt the listed landlords when we're imposing a regime which has to be paid for by other landlords. So I think the two most compelling reasons that I've thought of, and I did think about this quite long and hard, and I know as a party we've discussed it, and I'll be interested to see what the Minister has to say. The first thing is to say, should I make a song and dance of this? But I've been a States member now 15 years. It was my anniversary on Sunday. And strangely enough, I'm the only member left from the class of 2008. There's nobody who was elected for the first time in that year. They've either left or there were lots who were here before me. And the reason I mention that is not just out of self-indulgence or gratuitousness, but because from day one in the Assembly, I started to get phone calls, emails and correspondence to do with housing. And the housing conditions where people have been inadequately housed aren't limited to the private sector. Those phone calls come in from all areas. And in fact, only in the last few months, I've taken casework from the private sector, which I've had to refer to environmental health, and I've had to stand by metaphorically and hold the hand of tenants when they say to me, do you think I should raise this case with environmental health, or do you think I should proceed in another way? And I've advised them as I thought best. But I've also had to do that with at least one of the named housing providers on this list just in the last few months, who is still awaiting to be rehoused, even though she lives in substandard property, and that she would like ideally to be rehoused in a similar area. But we know that there are ongoing issues there. And I think the other point is that can we call it a social housing provider nowadays? I'm not sure, given the fact of costs, which are still very expensive, even in what used to be social housing in Jersey. The other reason is that we, as far as Andium Homes is concerned, need to lead by example, and I think the social housing sector need to lead by example. And to exempt them, I think, would send the very wrong message out to the many landlords in the private sector, some of whom, I would hope most of whom, actually take their responsibilities as landlord very seriously and want to do right by the tenants that they provide housing for, because they know it's in their interest and it's in the tenants' interest to do so. And I think to send that message out that actually we're going to be exempt from that, because that's how it will come across, but we want you to provide the cost for that service, because the cost is exactly the same, isn't it? If there is a complaint that gets referred and it needs to have an inspection from someone at the Environment Department to go round, maybe once or twice, check that the certificates have all been issued, check that it is wind and watertight and the compliance is there. The cost is exactly the same as if that happens to a private sector landlord. And I think for me, I think those two reasons in themselves bring me to the point where if we are going to have a fee, and remember, of course, that previous assemblies had the option to pass legislation where there was no fee at all. That boat has now sailed, I'm afraid. We could have had a system which was completely paid for by the taxpayer, if you like. It's now we've got a model which is, I guess, partly user pays, and that's where we're at. And it would make no sense to favour one group above another. So I think in terms of equity, fairness, I think we need to reject this, I'm sure, well-researched and well-intentioned amendment.
Deputy Brennan.
Thank you, sir. So I respectfully ask members to reject this amendment for two reasons. First, there is an important principle at stake in this amendment that I don't believe should be conceded. But second, there are also some practical issues that are raised that would create inequalities and confusions were it to be adopted. Let me start with the principles. The central point, our principle at issue, is that all those who are subject to regulation should be treated the same. If two landlords are subject to the same regulatory framework, then they should be treated by the law in the same way. It would be quite a significant precedent, I think, if we went against that principle. I'll return to that point of principle in a moment, but before that, let me address some of the practical issues that are raised. If we go back to basics, the amendment specifically excludes a number of social housing providers from the requirement to pay fees. However, several of those grounds could apply to other landlords. Why, for example, does the amendment not recognise the work of other housing providers that might also make a good case to be treated differently? What about housing providers set up by registered charities? What about parish accommodation? What about staff accommodation which does not achieve any profit? Drawing the net a little wider still, what about the many landlords who refrain from applying above inflation rent increases? What about large landlords with an impeccable record of high standard accommodation? Where do you draw the line? What precedent does it set to exclude one worthy category but deny others? Once you open up this possibility of excluding one category from fees, you start negotiating about them all. I guess some might say, why charge at all? That was a debate that, as referenced, has already been had in the past. I would say that from my point of view, it is a principle of regulation that where possible, those who are regulated should pay towards the cost of regulation. One of the reasons for that is, although it may not be fully accepted by all, is that those who regulate benefit from effective regulation. Good landlords are no longer undercut by unscrupulous landlords, for example. It's the same in planning. Much as I'm sure that planning fees are resented, they are an acknowledgement that the applicant will ultimately benefit from the application, and so it is fair that they pay towards the cost. The alternative is that the general taxpayer should pay, and I don't think that is desirable. It is quite interesting that this question has come up now, because it's worth remembering that this was looked at by a previous scrutiny panel when a previous version of these regulations came to the Assembly. And the scrutiny panel report published in 2020, February 2020, recommendation R7 of that scrutiny report aimed to ensure a level playing field across all housing providers, thereby suggesting the Minister should ensure that all rented dwellings under the scheme are not exempt from the licence fee. The quote from that scrutiny report goes like this: "The fairness of exempting social housing providers and parishes from the licence fee whilst private landlords pay fees is also highly questionable. Surely if fees are to be paid, then these should be apportioned fairly across the private and social housing sectors so that there is a level playing field. This is especially important given that one hears so much anecdotal evidence of poor housing stock in the social housing sector too." I believe that's also the view of the Jersey Landlords Association, that social housing should not be excluded. And on this occasion, I find myself, perhaps unusually members may think, in complete agreement with them. I would also draw members' attention to the comment made at the end of the quote I've just given, mentioning that there is anecdotal evidence that there is poor housing in the social housing sector as well. And this has been referenced as well by Deputy Tadia. And it does go beyond anecdotal. There are evidence cases of poor safety standards in the social housing sector. In the past 6 months, the Housing and Nuisance team dealt with complaints and inquiries regarding social housing rented dwellings related to insufficient heat in habitable rooms, water ingress and damp, and the safety of electrical appliances. This does not mean that the social housing providers concerned are poor landlords any more than it means that private landlords who have these issues reported are poor landlords. These issues can arise for many reasons, and particularly in the case of landlords dealing with some of those issues, it depends on when issues are raised by tenants. Extreme weather events can cause issues and so on. So the fact that issues are raised is not a criticism, it's just a fact. And that regulation therefore has to apply across the board. So it can't be argued that social housing providers should not be covered by fees on the grounds that they don't need regulating. They are within scope of the regulations, and that is necessary and justified because they occasionally fall foul of minimum safety standards, as do other landlords. The ultimate answer, though, as to why social housing providers, just like other landlords, need to pay a fee is that the alternative is the taxpayer should pay. And I just don't think that is right. We have a long-standing principle that those who are regulated should help pay the costs, pay the cost of regulation, and I don't think a strong enough case has been made in this case to exclude social housing providers, although they may seem worthy, and as I say, I think it would create all sorts of ambiguities and open up all sorts of other questions about who should and should not pay fees. So I'd urge members to please reject this amendment and stay with the principle of a uniform fee.
Deputy Scott.
Sir, just to follow up on the point made by Deputy Tadier that about the differences between the bodies that were identified in the amendment and private landlords. The simple difference that I could see was that what seemed to be identified were trusts and organisations that actually invest in housing, mainly that were charitable but were not exactly for profit, whereas private landlords generally are. So that, I guess, technically, I'm sure the secretary can say that the fees that otherwise would be going out of these trusts and things to support housing aren't really doing that work. I think I appreciate what the Minister was saying about if they don't pay, the taxpayer will have to, but I can also see that we need housing, and that there needs to be a way of supporting this, although he might argue that this is relatively small beer, but then if it is, then why actually be taxing these actual organisations that are actually doing the work that they're doing with that particular focus? I'm still sort of like listening to the arguments.
Does any other member wish to speak on this amendment? Right, Arbison Brillard.
Thank you, sir. The licensing scheme, as proposed, aims to provide government with an effective mechanism to identify rental homes and to proactively manage and improve the quality of homes. However, the appropriate approach to achieving this objective seems to me is considered to be different in relation to the private sector and the social housing sector, given they have a very different oversight and financial model, ownership arrangements and, of course, social purpose. If you take Andium, for example, it's wholly government owned, it's registered with the Rent Safe scheme, and this confirms that the government already know where those social housing properties are, and officers have the opportunity to inspect properties in order to register them with that Rent Safe scheme. Government has complete transparency about the homes owned and operated by Andium in particular, and operates an oversight model in accordance with a memorandum of understanding. Andium is also governed by an independent board, including housing experts. In addition, sir, it operates a clear complaints process if tenants have concerns about their properties or the service they receive. And that'll also be subject to independent reviews if necessary. They operate a form of rent control following the government's social housing rents policy, and this has seen reduced rent rises over the years to 75% of private market. 100% of their homes meet local social housing standard, which mirrors the UK Decent Home Standard, and consistent investment in maintenance to maintain this. Therefore, there's no doubt the government has already sufficient oversight over Andium particularly. And I mention Andium because bear in mind that Andium manage some 4,500 properties in the island, the biggest landlord in effect. Tenants benefit from good quality homes at below market rents, and so the licensing scheme isn't considered to add material value to their tenants. Despite this, the cost of the scheme would most significantly fall to Andium. Licences will cost £60 for 2 years, and although this has been indicated for those registered with RentSafe, the first period will be free. There will be a requirement to the landlord to register, which will generate $350,000 for government every 2 years. So the cost to Andium will be $150,000 annually. So we're dealing with a non-profit organisation, so the additional costs will ultimately be borne by the social housing tenants to effectively fund a scheme which will benefit private sector tenants. So, sir, one rather feels that this is a bit of a circumlocatory situation, which will give the tenants no benefit, but it'll simply fatten up the Minister's department for providing a scheme which they don't need. So, sir, on that basis, I think this proposition, this amendment, should be supported in the interests of states' housing, social housing rented tenants and others who fall into that category. Thank you, sir.
Right, does any other member wish to speak on the amendment, the second amendment? No other member wishes to speak? Then I close the debate and call upon Deputy Luce to respond.
Thank you, sir. I'll just start by pointing out, sir, that there are 6,367 individual dwellings that are classed as social housing, social rented housing, and of that number, as the Constable of St Billars has just said, the actual number is just over 4,800. So the cost to Andium on an annual basis is going to be nearly £145,000 annually. Now, some members have argued that actually their constituents need to move, they're in poor quality accommodation, and that charging the social landlords a fee is going to make that better. The Minister spoke about the cost of inspection being the same, but I can't understand how members can't see that allowing Andium to keep £145,000 a year is better for their tenants, is better for their properties, gives them more ability to build more, to maintain more, and to improve more. The Minister said, where do you draw the line? And he makes a point. Scrutiny panel have drawn the line on social housing providers. The Minister used the situation where planning application fees are the same across the board for everybody. But actually, the Minister usually, when he's the Environment Minister, Planning Minister, makes exceptions for charities and other good causes and allows a reduced fee. I'll just close with this, sir. Poor housing stock in social housing. I'm not denying that there won't be some poor housing stock in the social housing providers, but they're going to be covered. They're going to have to get a licence. What we're debating here is whether we allow, in Andium's case, them to keep £145,000 a year to do a better job of providing social housing for those tenants that need it, or whether we're going to impose a charge on them. That's all I have to say, sir. I think in Scrutiny's views, very clearly, we want social housing providers to keep that money and invest it for the benefit of those people who are their tenants. Thank you, sir.
Do you call for the appel, Deputy?
I do, sir. Thank you.
And as called for, I invite members to return to their seats. The vote is on the second amendment to the 11th Amendment, therefore Regulation 2. I'll ask the greffier to open the voting in just a moment. Yes. I'm afraid an errant mouse has delayed the matter for a short period. And the greffier has opened the voting, and I ask members to vote. Members have had the opportunity of casting their votes. And I ask the greffier to close the voting. The amendment has been defeated, 7 votes pour, 33 votes contre, 1 abstention. Very well, we now return to the debate on Regulation 2, which has now been legislation now proceeds unamended. Does any other member wish to speak on Regulation 2 in its current form? Connie Harbison, 1? No. If no member wishes to speak, then I call upon the Minister to respond.
So I feel that we've debated the main issues around this, which were around the exclusions and around the fees. The rest of the regulation is, I think, reasonably uncontroversial. It covers issues such as what the information the Minister must provide prior to the scheme going live, and that is listed in Clause 3, for example. But I think I hope members have had a chance to have a look, and I just recommend that we vote for that regulation now. Thank you.
Those in favour of adopting Regulation 2, kindly show. The appel is called for. Invite members to return to their seats. And I ask the greffier to open the voting. The voting is on Regulation 2. If members have had the opportunity of casting their vote, then I ask the greffier to close the voting. The regulation has been adopted, 31 votes for, 4 votes contra, no abstentions. Minister, do you propose regulations 3 to 6?
Yes, sir. Can I propose them en bloc?
Indeed. Are regulations 3 to 6 seconded? Yes, sir. Does any member wish to speak on regulations 3 to 6 or any of the Corrie St Mary?
Thanks, sir. I'd like to speak in relation to Regulation 5 in particular, sir. This effectively is a replacement of the relevant or the corresponding provision in the original proposition where the right of appeal was confined to 5D, a right of appeal to the Minister if a licence is refused or withdrawn. End of. Members will note that the review we now have is, it is a review and an appeal. I think in recognition, and the Minister recognises this, he wishes to adopt a softer touch and rather than throw anyone into the melee of applying to the Royal Court. So we now have a two-tier situation where there's a review in the first instance, not an appeal, where perhaps informally it can be agreement can be reached, and if not, then there is a right of appeal to the Royal Court. And I also distinguish the fact that in the original proposition, any approach to Royal Court will come by way of judicial review, which I'm told is an appeal of last resort, but you might have your own views on that, sir. Whereas we do now have in this legislation an appeal process which sets out the parameters and in fact is closely allied to the appeal provisions of the 2018 law, which makes sense. And I mention that, sir, because as I said in another debate, the Law Commission in a report, I think 2018, did point out and focus on the fact that it cannot be right that an appeal against a particular provision should lie to the Minister of that very department who has created the law. And I like to think that this may indeed serve as a template for any future legislation, and that across the whole ministerial profile, ministers will avoid this, including provisions where appeal lies to them, and they will insert and provide for appeals to the Royal Court, setting out the grounds for appeal and the timetable, etc. And so I wish to make that distinction, sir, because I think it is important for the benefit of all future legislation as well. So I very much support this particular provision. Thanks, sir.
Any other member wish to speak on those? Deputy Curtis, Alex Curtis.
Thank you, sir. I do want to highlight, I know the discussion of fees came up, and Regulation 3, paragraph 5 highlights that a licence, it was a later paragraph in
the licence, it was paragraph 6. There we go, I got a little ahead of myself. The Minister may impose charges for the issue of a licence, and if charges are imposed, they must be published. So I would argue that the Minister has provided provision within these regulations to charge. He has not said he must, as a debate around regulations existed earlier. I remain concerned about the flexibility within the wording of that regulation, notwithstanding assurances that this will not be above inflation or 2.5% without Treasury approval. I do highlight that in the report alongside these regulations, that it says that under a paragraph review, the intention would be for officers to review the scheme after a year of operation. This would help inform the level of fees that would apply for the next renewal period. So I say I'm struggling to marry the two of those up. I, like many of my parishioners, have great concern about the creep of user pays and the feeling that it provides no restraint on departments for thinking prudently. And I urge the Minister to exercise his powers, as if this is approved, that he may impose charges, but he doesn't have to. And I'd prefer that he find alternative funding, and for the first year at least, provides a scheme with no charging whatsoever.
Deputy Scott.
Thank you, sir. I just noticed with a bit of a discomfort, Article 3.5, the licence subject to the standard licence conditions set out in schedule and may contain additional requirements if the Minister thinks fit. I would have preferred, and I just regret not having brought some sort of amendment or discussed this with scrutiny, something that perhaps gave more in the way of guidelines about reasonableness or the basis. I just am not keen on what can perhaps just be a carte blanche in terms of discretion.
Does any other member wish to speak on the regulations? 3 to 6. Another member wishes to speak. I close the debate and call upon the Minister to respond.
Thank you, sir. Thank you, sir. So, to respond to those 2 points, the Constable of St Mary's points are well made. I'm happy to accept the reform, if you like, to the appeal system. I think a two-tier system with the second appeal to the Royal Court is a good option, and the option is in the first instance to appeal to me as the Minister. Some people may have said that that's too much marking my own homework. The officers in my department will confirm that I'm quite capable of holding them to account if necessary and disagreeing with them. But we do have now the backstop of a legal fallback as well. But I would emphasise again that the intention is for these provisions to be applied flexibly and in a way that is persuasive compliance is the phrase that is used. It's intended to be persuasive. We should not be getting to the point where people feel they need that kind of draconian response, and I would hope we don't, but there we are, the provisions do exist. In terms of fees, I will stand by the points I made. I can't say to Deputy Curtis that we won't charge in the first year. What I have said is I've very clearly laid out the fees. I've explained where those figures came from, and I've said that they will increase by no more than inflation on any given year. And that is, of course, in any case, there's also another restriction, if you like, in that any fee rise above 2.5% requires the permission of the Treasury Minister. So there are further restraints in place, and so obviously members will be aware that ministers come and go. My guarantees can't be held for all time, but I am very sincere in my desire to keep those fees low and to get them to reflect the costs that we actually have, not some future costs that might arise out of the expansion of the system. We have enough officers to do the job if we pass these regulations so that they can do the job properly. So those fees should not need to increase further. With that, I'll close and call for the vote, please. I think we'll have the appel.
That is called for. I invite members to return to their seats. The vote is on Regulations 3 to 6 in second reading. And I ask the referee to open the voting. Members have had the opportunity of casting their vote. Then I ask the greffier to close the voting. The regulations 3 to 6 have been adopted, 37 votes pour, 4 votes contre, 2 abstentions. Do you propose the regulations in third reading, Minister?
Yes, sir. I beg your pardon.
Is it seconded for third reading? Does any member wish to speak in third reading? Deputy Luce.
Thank you, sir. And this may be a little bit unusual, but I'd just like to a few votes of thanks. When my scrutiny panel called this in, we hadn't quite realised what we were taking on. But I'm extremely grateful to Justice for Tenants UK, who have been hugely of assistance to us in coming up with our recommendations and our amendments. I'm grateful to members for agreeing with us in many of those cases, and I'd like to thank my scrutiny panel and our officers in particular for the huge amount of work that's gone on here. Members may not appreciate quite how much. Obviously, there were 9 amendments. The Minister accepted 7. We had the 11th amendment. There has been a huge amount of backwards and forwards in agreeing with law drafters, with law officers, with the Minister. It's been a big piece of work. I would just say in conclusion, sir, that in our comments paper, the scrutiny panel have also made some recommendations, which I very much hope the Minister's going to take on board. We've spoken about a code of practice, so I won't go on about that. But we've also recommended that the Minister explores other inspection regimes that already exist to avoid duplication. We would like the Minister to implement a government helpline for landlords and tenants regarding licensing queries. We'd like him to undertake an economic impact assessment, which he doesn't seem very keen to do, but anyway. We'd like data to be collated and provided in an annual report so we can see the value and effectiveness of this licensing regime. And we'd also like to publish the names of those who are in breach of the law. And finally, sir, one that I think is quite important that we certainly were very keen to put on as a recommendation is the potential for the Minister to consider introducing fixed penalty notices for breaches of this law. Now, I know that goes away from many of the things we do in Jersey, but we were hugely impressed by the work that's been done in the UK, where a prosecution normally may take 18 months to 2 years and cost hundreds of thousands of pounds, where fixed penalty notice could get the person who's broken the law into a situation where they pay a fine in a very few months and cost the department a very small amount of money, and we think that that could well be investigated as some way forward. So there's a little question in the panel's mind, the poor conditions in rental properties do exist, and this should be addressed. The question we've sought to answer is whether the licensing regulations are going to achieve their intended aims and without an adverse effect or unintended consequences for the private rental sector. We do not feel we've been able to answer all the questions with a huge amount of certainty. Whilst we understand a code of practice is currently being drafted, and we've discussed that, it is unfortunate that it wasn't prioritised to be published in time for this debate. And the absence of it, we feel, makes it difficult for members to ascertain how the law will be applied in practice. Notwithstanding that 7 of our proposed amendments have been adopted, sir, our uncertainty remains as to whether the proposed licensing scheme will achieve its intended aims of making rental dwellings safer. However, if adopted, we hope that both our proposed amendments and the recommendations will assist in some degree in ensuring that suitable mechanisms are in place to ensure that regulation is both light touch but also has the best chance of achieving its intended aims. My panel went into this work, sir, knowing that the principles have been adopted, and we only seek to improve the regulations where we did. I finish by thanking the Minister, his officers and all stakeholders who have contributed their views and evidence for the work that Scrutiny have done. Thank you, sir.
Does any other member wish to speak in third reading? Conitap. Deputy Balash, yes. Sorry. Does your own button not work, or is it I can't see it?
It's the fine head of the constable. So the scrutiny panel, and I'm happy to follow Deputy Luce, has indeed done a very good job in improving the regulations in different ways. But if I may say so, it has failed to identify the fundamental flaw in this licensing scheme. And that flaw is that the regulations do nothing to achieve the purpose which the Minister claims for them. That purpose is dealing with the poor quality housing, helping people desperate for someone to do something about their living conditions. The Minister spoke very eloquently and persuasively in the first debate about the need to do something for tenants who suffer from dampness or mould or unsafe electrical or gas systems or vermin in their homes. I sense that many members felt unable to resist that avalanche of emotion. The real tragedy of this long debate, in my view, is that a landlord's licensing scheme will change nothing. I fear that Caritas and the Citizens Advice Bureau and hundreds of tenants who have been told that licensing landlords will make things better are going to be very disappointed. Nothing will change because only the naive can believe that bad landlords are going to reveal the dampness, mould, and unsafe systems in their properties when they apply to be registered. The only way in which the authorities are going to learn of rental properties where living conditions are inadequate is through direct complaints from the tenants or information passed through Caritas and CAB and other such organisations. In other words, exactly the system that we have today. What is even more upsetting to me is that the means of dealing with the problems of inadequate rental properties exist already and have nothing whatever to do with a landlord's licensing system. The Minister has said that the only means to enforce against the landlord who refuses to make improvements is a criminal prosecution. And I'm quoting from Hansard, but he also said exactly the same thing this afternoon. And that is just not true. Failure to comply with statutory standards can be a criminal offence. But there are also civil remedies available to the Minister, and it is incomprehensible to me that they are not being used or not being used sufficiently. Let me give, sir, a very simple example. The department learns of a tenant with a kitchen wall covered in black mould. It's a prescribed hazard, and it is said that children in the flat or a child suffers from asthma and is being affected by the mould. An inspector goes out, and during that inspection he decides that the remedy is some mechanical ventilation. The landlord is reluctant to spend the money to do the work. The inspector goes back to his office and drafts an improvement notice under Article 9 of the law, requiring the owner to reduce the risks posed by the mould by installing mechanical ventilation within, shall we say, 8 weeks. Hopefully, the owner will comply. But if he does not comply, the inspector has power under Article 12 of the law to have the work done himself and later to recover the cost of doing so from the owner. What could be simpler than that? Problem solved. Tenant satisfied. So much better than a criminal prosecution where the owner may be fined in court, but the mould is still there on the kitchen wall. Conditions placed on a licence are irrelevant to the issue of how to get rid of the mould, because the only remedy under these regulations against a failure to comply with those conditions is a criminal prosecution. Sir, I have gone on long enough. I'm going to vote against these regulations in third reading because they create a worthless set of controls which will do nothing to improve the quality of rented dwellings in Jersey.
Deputy Taddy.
Thank you, sir. We're in an unusual position that we've got a piece of legislation before us that has been very well scrutinised in the first, second and third readings, and not just on one occasion, but on many occasions. And that's how legislation is developed in most places around the Commonwealth and around the world. And I think we've found ourselves in a position, hopefully now, where we've got a much better law for that. And I think we do need to acknowledge the work that this scrutiny panel has done, but also that many others who have done in previous assemblies who may not be here with us and who haven't been able to necessarily achieve what the good Deputy and Minister for Environment, Planning and Environment have done today, hopefully, in the third reading. Now, I disagree with the pessimism of the leader of the Jersey Liberal Conservatives when he says that this law will change nothing, because I'm actually much more hopeful that actually this does give a very necessary string to the bow of enforcement in housing and in environment. And the reason I say that is I think a couple of false analogies have been made, and also some conflation by the previous speaker as well as Deputy Luce. The way I see this is that you could have an analogy where we're not talking about accommodation and housing, but you're talking about driving in cars or mopeds. And you might say, actually, why do we need a licensing scheme for drivers? Why don't we just wait until there's an issue? If there's a complaint about how they're driving, then just wait for that complaint to happen. And if somebody sees a driver who is being, discourteous, but actually or more dangerous and has done something wrong, then we wait for them to be reported, and then the police can deal with them. And perhaps they can be dealt with in a light touch way, but also with an on-the-spot fine. So, and also their names can be published, which was, interestingly, the suggestion from the leader of scrutiny. Now, is it just me, or was that quite incoherent and not joined up? To say, on the one hand, we want to have light touch regulation, which is a great Jersey way, but actually, is it going to be effective? What I want to see is effective regulation. And of course, I want to see that done in the most sensible way. But it seems to be contradictory to, on the one hand, say we want to have light touch, but we want the names published of any landlord who's made a breach. I mean, we don't do that for other laws, and it doesn't seem compliant with data protection or with the natural laws of justice that we enforce in other areas. So I think that's a slightly strange suggestion. It's much better to actually have an ability, and I'll give you a tangible example of something that's happened recently, and the Deputy Balash will know this person. So I've come across a case of a landlord who, for example, knew his or her rights when it came to increasing the rent by the cost of inflation. So the tenants had a letter through the door saying, the current rate of RPI is 12%, therefore your rent is going up by 12%. But then a few months later, the tenant realised, or it came to the attention, that the landlord hadn't done an electrical check. So even though it's in law that you have to have an electrical check, that hadn't been done. The gas check hadn't been done. Therefore, the tenants, who are now paying quite a lot of rent for that home that they're living in, have had no way of knowing that they've been safe for the last 18 months of that tenancy. So that's already in the law. And of course, if you don't know who the landlords are in the first place, how can you possibly make sure that they've got all the right paperwork in place? The government, no government is able to do that. So simply, this isn't about having black mould on a wall in a bedroom or a kitchen. I mean, that's quite a separate issue. But what it does, it makes sure that you set up a system in the first place, is that if you want to be a landlord in the social or private sector, you can be as ethical as you like, but everyone's going to be on a level playing field. And we need to make sure that you fully understand the obligations that you have legally under the various laws that we have. It could be the residential tenancy law, it could be the minimum standards for rental dwellings, it could be the lodging houses law, and that you know exactly what your legal obligations are. And then, of course, we accept the fact that things can happen out of the blue. If you've got tenants who haven't told you about an issue for the last 18 months, 2 years, and they only decide to tell you a few months before they want to move out, of course you're not going to have known about that, but at least you've known about what your legal obligations are. You've paid in your deposit to the deposit scheme. There's no reason that a landlord who takes a deposit won't do that, and that's an offence in its own right. You have the relevant electrical checks every so often as you need them, otherwise you will be in dereliction of your duty. But like I said, you can't expect government to enforce that if they don't know who those landlords are. So I think it's very much two different issues. The last issue that I would also raise is that, yes, we shouldn't expect this to be a silver bullet. I think that the Environment Minister, as well as the Housing Minister, especially following Storm Ciarán, should be doing a lot more about alerting landlords to their duties and obligations and tenants to their rights, because the residential tenancy law, for example, says very clearly, sir, that if part of your property becomes uninhabitable and you're a tenant, you don't have to pay the rent for that part of your property. And if you've got a window that's blown out and you can't use your bedroom, then you need to be going to your landlord and saying, actually, I can't use this bedroom. I accept the fact you may not be able to fix it straight away, but I will be expecting a rent reduction. Do we ever hear those kind of things promoted anywhere in our communications? No, we don't, because I think it's sometimes too difficult. So I hope that we are now in the third reading at the point where we can come together on this. It's been a very relevant issue. We know it touches on the rights of children as well. We know it touches on the right of outcomes for the most vulnerable in our community. And I hope it's now something, with the scrutiny that's been done, that we could all get behind and vote for unanimously and move on to say that we expect better housing standards right across the board.
Deputy Scott.
So I think that my overall concern about approving laws that give people powers is actually, do I know that they work? And the concern I have here is the experience I have had in different areas of the Minister's department regarding the proactivism with which they have enforced powers in the past. And I think that's not necessarily to say that it was just because they weren't bothered, but sometimes that there are the consequences of enforcement that may well mean that light touch becomes no touch. I have been somebody, I mean, Deputy Balash mentioned living in a flat with mould in it. I have actually lived in a flat with mould in it. And did I complain to the landlord? No, I didn't want him to put up the rent. And this is the issue. It's, are you going to change a regulatory culture with this law, or are you going to basically be saying, we passed this law, aren't we great? We've done so much for the community. And yet, if you haven't actually really dig down into why certain laws, certain powers haven't actually worked so far, then maybe you're looking at the wrong thing. And therefore, when I push that button, I have to think, is this going to produce the right result? Is this actually going to improve things for the people that we actually do care about? Or is it going to create more of a convoluted red tape business matter, which I'm sceptical whether every landlord's going to, down tools in response to this, but it does. I'm just aware that the compliance with regulations, the cost to businesses of doing that is costing millions to this community, tens of millions. So I don't really feel able to say, yeah, okay, that's a good job done by pushing that button.
Deputy Hull.
Thank you, sir. I'd just like to make one point that no one wants anyone to live in substandard accommodation. But my worry is, with this licensing, what will happen to families who are living in substandard accommodation, for whom the minister says that they are unable to live there anymore? Where are they going to go? And I don't think we've thought about that part of what we're doing sufficiently enough. If a lot of people are living in poor accommodation, where are they going to be rehoused? It's a quandary, sir. But I stood for less bureaucracy and less red tape, and this government seems to be bringing more and more and more. And quite frankly, I've had enough. Thank you, sir.
Deputy Moreau.
Thank you, sir, and I'm pleased to pick up from Deputy Howell, because I do worry about bringing in more and more regulations across the board, anywhere. It is becoming a big drain on our economy, I can tell you now, and was speaking to various people just over lunchtime on that exact subject. But so I just particularly wanted to pick up on something that Deputy Howell said, which I do hope the Minister will put in the Code of Conduct when we see it. And that is, what will happen to people if they are said that they cannot stay in this accommodation any longer because it is substandard? I raised this when I was in scrutiny, and I said to the then Minister that it was a serious concern. And I was concerned at the time that the response kind of said, well, this isn't really, this is regulations about licensing. It's not what we do with it. And I agree, the regulations themselves are dry and they are matters of law, but the Code of Conduct isn't. And so I implore the Minister that when he brings out that Code of Conduct, it does say very clearly how people who have to leave their accommodation because it is found to be unsafe, what will the government do to house them? Thank you, sir.
Very much. Deputy Gorst.
Thank you, sir. You're being very generous in third reading.
I am.
Appreciate.
I was reaching the point of reminding members that debate on third reading should be whether or not one adopts or doesn't adopt the regulations. And clearly people have felt that they wanted to make more general points. But I take that reminder on board, Deputy, but you have the floor.
Thank you very much. And the reason I just mentioned that is that I, for one, have been, and I hate this term, on a journey, because I probably, all those years ago, started with a similar mindset to Deputy Balash, and as he was speaking, what he said resonated with me, and we've just heard Deputy Howell say she's had enough of regulation, and I'm pleased to hear that and hope that that will, when other bureaucracy comes forward, she'll take the same view. And I have been contacted by a number of parishioners, as I know all members have. And I started off with that view that it was a bureaucracy that would not deliver to deal with substandard accommodation. And I talk about the accommodation rather than the landlord, because every landlord that's contacted me or I've spoken to has no problem with the standards required in the underlying legislation. Their concern is that they want to be or continue to be good landlords and therefore want to be able to comply with the underlying legislation. And I know that the Minister is committed to providing, whether we call it guidance or codes of practice, and that will be a critically important part. And I hope that as he responds to this somewhat broad third reading debate, he will reassure that all those good landlords out there, some sitting in the gallery, who believe that this particular nut could have been cracked a different way, and I don't disagree with them. I think there could have been a different approach to gathering information and names and address registers and all of that, but we are now where we are. And the reason I've changed from being really concerned about a licensing system to thinking actually good landlords have nothing to fear is because they're in the terms of conflicts. I think we have this idea of a relevant connected person, and I have a relevant connected person, and that relevant connected person has I'm not sure if transitioned is the correct word. I've got to be careful with that word these days. They have moved a building which was registered under one piece of state's legislation to the lodging house regulation. And it can appear, I think, on the surface that that legislation itself is bureaucratic. But I've got to say, sir, whilst there are some annoying things about whether a Victorian banister is suitable for current health and safety, and we could argue that all day, and I know the Minister would enjoy that argument, the reality is that the officials involved in supporting that legislation are reasonable, they are understanding, they give appropriate time, and I think that the product at the end is a quality product. Now, you can argue that that's one of the reasons that some people have gone out of lodging houses, but I would argue that what it's done is raise the standards of lodging houses in a positive way. So rather than us thinking there is a lot to fear from this licensing system, I think actually it will level the standards right across for all landlords and all those who are providing a very necessary public service. We know that there are many islanders who rely on accommodation that others own, and it is an important contract, not just the written contract, but the contract of owning a property and wanting your tenant to remain and enjoy that property safely and to feel that that property is their home. And so I've gone on that journey and think that actually this can help in that provision. And my message really is to those landlords who are fearful and who are concerned what it means to them, that they'll see the guidance and they'll see that to very large part, they're probably more compliant than the law is going to require or the licensing system is going to require. But what this system will allow is that those properties which are not up to standard, which has always been the point of argument, some have argued that, well, the officers have already got the powers to deal with these issues. Officers have argued back that actually in practice, they haven't really got anything suitable that allows them to do it on a non-tipping off basis, and that's led to other unintended consequences. And so this will allow them, I think, to deal with those properties which are not up to standard and which no one I know, whichever side of the debate today, is supporting and proposing are acceptable. And so I've arrived today accepting this as a solution at this point in time, but the code of practice and the guidance will be extremely important to reassure good landlords that they're already doing the right thing, and I hope the Minister will say that as far as he's concerned they don't have anything to fear, and I know the Landlord Association are up in the loft, and I understand the concerns that they have raised, but I don't think their members really have anything to fear. I think that there is an issue about cost. The Minister has commented on that cost. I believe that if their members or any landlord, well, he'll deal with the cost, are struggling with officials and are finding them that they're not reasonable, then I know that his door or his desk is always open. I know that whilst piled with paperwork and numbers, mine is too. And I know that the Chief Minister as well is always prepared and happy to listen where things are not working well in the service that government is providing. And so that's why, sir, after a number of years of not being happy with it, and bearing in mind that in a different iteration and a different government plan, what seems like many years ago, the Minister was given money and given officials to carry out this work. So he's not growing a bureaucracy in bringing forward this legislation in the traditional sense of the word. What he's trying to do is ensure that his officials have the appropriate tools in their tool set to deal with those properties which are not up to standard, and therefore I hope that members might, even those who don't like bureaucracy, and I count myself as one of those, might today think that this actually is, if there is such a thing, good bureaucracy, and it will deliver a good social policy outcome. Thank you.
Deputy Ward, you wish to speak, I think. If I, without signalling you out, if I could just remind members what I said before, that the debate in third reading should be whether or not to enact these provisions in third reading. I have allowed a lot of leniency in terms of where people have gone with their speeches, but I'm conscious of the amount of work that has to be got through for the rest of the week. Yes, Deputy Ward.
Just briefly, sir, because I have been involved in this before and I've been through my own journey, often of despair with this. And I would say welcome, I can't resist it, I welcome Deputy Gorse on his journey, and I'll say to him, don't stop believing. Because we'll finally get there. I could quote the time. We will finally get there with this, and I welcome this, and I urge members to do so. I will certainly be voting for it because it does give a structure to one of the most important things that we have, which is the homes that people live in. And I congratulate this Assembly, should it vote in third reading, on passing this, and that's moving forward. So, thank you.
Deputy Tom Binet.
Sir, I probably won't be wise for me to speak at length, so I'll be extremely brief. I always find it interesting to listen to what people have got to say, and I have to say this whole business has troubled me for a very long time, and the business of introducing unnecessary bureaucracy, as mentioned by Deputy Howe. But I have to say I found Deputy Bullosh's speech extremely compelling, and I hope members took note of the detail of what he had to say. Thank you, sir.
Connétable St Brelard.
Thank you, sir. In talking the third reading, particularly, there are a couple of areas which do concern me, which haven't been addressed, and I would urge the Minister to look to these in due course. The economic impact was mentioned, and I don't believe work has been done. I believe that we will see landlords getting out. They'll be selling their stock, and the question is, will it be picked up by others, or will it go be sold into the private sector? Because there is a point, sir, at which people will tip, and the returns on property investments will vary. Some will say they're only getting 3% at the moment, so some will be getting more, depends on what it's cost them in the first place. But I think that's always a point which needs to be considered by the Minister, because we do need to encourage private landlords at the same time as imposing regulations. So, and finally, the scrutiny panel, despite best efforts, actually had quite a lot of difficulty in getting feedback from tenants towards these regulations. We were really trying to understand what the position was. Yes, there's a lot of anecdotal evidence by political colleagues, but my own research has brought out a couple of points which the Minister may like to consider in due course as to why tenants were dissatisfied with their position. And one was fear of revenge eviction, which you heard about. Another was lack of choice. Another was moving fatigue, which I thought was quite interesting. And of course, can't afford better. They don't know the rights, language problems. And finally, sir, the interesting one I thought from my point of view was the slow, clunky and impersonal nature of the environmental health complaints procedure. And I would ask the Minister to seriously consider that point. Thank you, sir.
Does any other member wish to speak in third reading? No other member wishes to speak in third reading. I close the debate. Call upon the Minister to respond.
Thank you, sir. So the proposition we have before us has been well tested. It has been improved by the stress testing that comes from a searching examination from Scrutiny. And I would add my thanks to Scrutiny's officers and the panel for the work they've put in. I know they put in a lot of work and I appreciate it. And it's also been improved by the criticism of those who I know would rather it was not coming forward at all. But I would say that this proposition has been on the runway for some time. Several previous attempts to get in the air have ended up with takeoff aborted, sometimes at the very last moment. And I think now it's time to get airborne. We now have an amended proposition that I'm happy to support and recommend to the Assembly. And I would say, just to recap, we approved the principles in June, recognising the need for a licensing scheme, and the regulations gave a proportionate and flexible way to ensure that rental properties are safe. It is fundamentally about the safety of rental properties. Since 2018, we have had a law that sets minimum standards, but in practice, it has been difficult to enforce. These regulations, this licensing scheme, will give us the tools we need. To respond to Deputy Balash's point, do we have the tools already? You mentioned conditions that can be imposed. Yes, in fact, I checked with officers. We've imposed 189 of those in the last 5 years. They are a useful tool. They will be a more useful tool when we have the additional ability to make those conditional on, to make the condition being that if work is not completed, then a license can be withdrawn. That is a more powerful and a more flexible way of using those conditions in the future. Other questions that came up, Deputy Howell asked, where will people be rehoused? Well, that's the same situation as we have now when people need rehousing in extreme circumstances. I cannot emphasize enough that these regulations, this licensing system, is not going to lead to mass numbers of people suddenly having to leave their homes. The whole point of the scheme is to allow for conditions to be attached to licenses, to encourage and to mandate improvements, and that is done sensibly and proportionately by persuasive compliance, so that, for example, it reflects the fact, if we all know there's been a big storm and you can't get contractors in, then obviously there's a longer time period to comply. That's the common sense method of applying these kind of conditions. And so the question of what will happen to people who need to be rehoused, it will be the same as now. If somebody is rehoused, government agencies are in place to help with that. But the only circumstances in which license withdrawal would happen would be if a house was so dangerous that to stay in it would be potentially a serious injury or a death. And there are so many other ways that these tools can be used, so many other conditions that can be used to keep people in their houses. That's the point, to keep people in their houses whilst improvements are made. For example, it might be that a room is ruled out of bounds until a hazard in it has been fixed. There are ways of dealing with this that come with this scheme, with this licensing scheme, that will mean that there is less likelihood of that draconian step being taken. just to reiterate on the code of practice, it will be forthcoming. I've always said it will be forthcoming before the regulations come into force, and it will be forthcoming, and it will be amendable, as many members have pointed out. It's not a statutory instrument. It can be amended as we go along and as we get feedback, depending on how it's operating. And I would add to that that we have promised to review the scheme in a year and see how it is working and report back. And if there are problems that have arisen, then we will deal with those as we go along, and that might be through the code of practice. It might be through other amendments to the scheme that are necessary. But I would reiterate, let's get the thing airborne. Other questions that were raised were economic analysis. My view is that this licensing scheme is about irreducible minimum safety standards. They are not tradable. There isn't a kind of, let's see whether the cost is justifiable or not. These are minimum safety standards. When we get to other things, things like energy performance certificates, which I know landlords have raised as issues, we've already listened on that and pushed them back. These are things that are different to, these are things which are not not related to the fact that we need these minimum safety standards, and therefore economic analysis is not, in my view, the appropriate way to go. The point about this scheme is that it is a twin scheme. It gives us two things. It gives us a scheme which encourages tenants to complain, to be able to bring forward their complaints in a more secure way, because they're more likely to be anonymous, or not for the landlords not to know that they've made a complaint, and it gives us a flexible enforcement tool. It has been improved by scrutiny, by making the regulations more tightly drawn, so there's less discretion for the minister. And as I say, I've accepted those, almost all those amendments, and we've been through the other two where we didn't. So I urge members to support these regulations. It will help us improve conditions. It will allow us to enforce minimum standards, and therefore it will help those people who keep coming to us and telling us that terrible conditions exist for some of the most vulnerable people in our society. There are plenty of good landlords. I am happy to reiterate the points that have been made by several other speakers. Good landlords have nothing to fear from this. They will already be well in excess of the minimum standards, and they will simply be required to fill in a form once every 2 years. These regulations address that minority of circumstances where we've had a persistent and long-standing problem that affects some of the most vulnerable people in the island. And my belief is that once these licensing regulations are in flight, I think it will prove to be a far less bumpy road than it was feared. I urge members to support this proposition.
Do you call for the appel? Let us call for. I invite members to return to their seat. The vote is on the adoption of the regulations in third reading. If members are ready to vote, I ask the referee to open the voting and members to vote. If members have had the opportunity of casting their vote, then I ask the greffier to close the voting. The regulations have been adopted in third reading, 37 votes pour, 9 votes contre, 1 abstention.
Could we have the 9 and the 1, please?
Those voting contre, the Conotabs of St Brelard, Trinity and St Juan, and deputies Hegra, Balash, Scott, Rose Binet, Powell and Tom Binet, and Deputy Lewis abstained.
Very well. The next item is reform of the composition of the States Assembly, lodged by Deputy Scott. The main respondent will be the chair of PPC. There's an amendment lodged by Deputy Farnham. Do you accept the amendment, Deputy Scott?
I don't, sir.
You don't. Very well. Then we need to read the proposition and then put the amendment. Read the proposition. Ask the greffier to read the proposition.
States are asked to decide whether they're of opinion A, to agree that the number of deputies in the States Assembly should be reduced and that the office of Senator, elected on an island-wide basis, should be reinstated in time for the general election in 2026. B, to request the Privileges and Procedures Committee to develop proposals that will determine the number of deputies to form part of the reconstituted States Assembly in 2026 in accordance with the following principles. 1, there should be no increase in the total number of States members from the current 49. 2, the 12 Conotabs should remain as voting members in the Assembly. And 3, there should be at least one deputy for each existing constituency. And C, that all of the consequential amending legislation should be brought for debate by the Assembly before July 2025 to ensure implementation for the 2026 elections.
Deputy. Deputy Scott.
So I'm confused. Is Deputy Farnham not going to put his amendment forward?
You need to make your proposition. It needs to be seconded. Only once it's seconded do we read the amendment and debate the amendment.
Okay, so I make the speech for the proposition now. Thank you. So the reason why I didn't adopt Deputy Farnham's amendment is simply because it is one way of doing things, and I'm interested to, I believe I need to explain a bit more about the background, which I hope I have put forward in the addendum. This proposition seeks to progress common goals that all states members share. The goals of improved democratic representation, improved governance, and value for money. The States Assembly has a role in both representation and governance. The electorate who elected us sought change, but they also sought improvements in government. It's no coincidence that I brought this proposition close to the time that state members are to debate the government plan. This is a time that invites all states members to consider public spending and whether we are making the best use of resources. So many states members have roles and political agendas that promote inclusivity and prudent public spending. We urge the public sector to eliminate inefficiencies and to organise itself effectively. We have supported a degree of policy reversal when we believe it achieves those aims. We cannot show true political leadership unless we are prepared to do the same in the way we organise our own recruitment and work towards promoting both inclusivity and efficiency. Before I explain why the States Assembly support of my proposition would deliver these things, I wish to acknowledge the work of the former Privileges and Procedures Committee towards positive democratic change. It was a difficult challenge that I described in the addendum to this proposition. Pressures were created by the limited time for the former States Assembly to consider successive proposals after they had considered much of the content of the first proposals crafted by the former Privileges and Procedures Committee. These sought to remove constables as voting members, which was rejected by the States Assembly. The Commonwealth election observers, who recommended changes to the composition of the States Assembly, they valued democratic fairness too. Their report in 2018 expressly recommended that 3 things be taken into account to optimise the democratic voice of Jersey's electorate. They were the requirement under international law to make voting populations reasonably even, the results of the consultative referendum, which supported the retention of constables in the States Assembly as voting members, and the findings of the Electoral Commission. The former PPC's work led to the creation of the current constituencies to compensate for the disparity in parish voting populations in response to the electorate's desire to retain the constables as voting members of the States Assembly. Although the former PPC might have proposed smaller single-member constituencies to eliminate duplication of constituency roles, they avoided such division, or maybe divisiveness. Creating constituencies was a positive step forward in meeting the electoral observer's recommendation. Yet a key finding of the Electoral Commission that Jersey's public strongly supported the retention of office of senator was not taken on board. This was despite 58% of submissions to the Electoral Commission supporting the continuance of senators, with most of those submissions seeking the retention of between 8 and 12 senators. In this respect, Ma'am, I acknowledge that my proposition may have seemed somewhat open-ended and a potential cull, but really I had those numbers in mind. The perceived democratic unfairness of the new system has led to continued division in our community. It cannot be satisfactorily explained away by saying, this simplifies matters for you, or your problem is you don't like change. Because what the former States Assembly did was to close a door to the chamber, and in doing so, reduce the chamber's own flexibility and its own inclusivity. I'm not saying that this result was intentional. Sometimes the best intentions do not go to plan, or important considerations are overlooked, despite the best efforts of states members. Some have unforeseen and unfortunate consequences. And when that happens, we need to support the electorate in addressing the matter swiftly, rather than become blind to the problem or allow it to become embedded. A true democracy seeks to include people, regardless of background, rather than to seek to exclude them. The door that has been closed is a resource that facilitates the representation of particular communities in the island. So in what way did island-wide representation offer inclusivity? Now, let me refer to two categories of people whose circumstances were accommodated by having the senatorial role. Often, those categories are one and the same. And I'm referring to the extremely hardworking and the immigrant population. Often, the two are combined. These are the people whom some may criticise for not actively integrating within certain communities, notably districts or parishes. But that does not mean they are not serving the community island-wide. Often they are working extremely hard to support the island-wide community and the island's economy, whether they are care workers, delivery drivers, or finance workers. The islanders they serve and associate with often are spread island-wide. Often the hours these islanders work don't give them adequate time to attend parish assemblies or participate in activities closer to their homes. Should they choose to stand in an election, their work commitments may not support a campaign predominantly based on door knocking either. Which one of us is to say that electoral campaigning should be conducted through door knocking rather than through social media, when that is government's preferred way of engaging with the public? What about the candidate who has a disability and is best known through work for a charity? Why should he or she be expected to conduct a campaign through door knocking? Conversely, some voters don't welcome door knocking and prefer to select candidates based on their work backgrounds or other characteristics advertised through social media posts or the Gref's booklets. There is no right or wrong here. This is about choice as all good democracies are. So why have we closed the door when we should be opening doors to candidates? Candidates who could well have useful skills for the role of governance and challenging governance adequately, including in the realm of public spending. And even if they don't, can represent communities that stretch across the whole island. Are we concerned that door provides an unfair advantage to wealthier candidates? Then let's address rules that give unfair advantage without seeking to exclude those who have contributed to the island's economy through hard work and who have particular skill sets that would support good governance as a result. Let's support candidates' choices between being independent or joining a political party without forcing them to join a party or become beholden to a private donor owing to financial barriers, because that way leads to divisiveness rather than diversity. Nothing in my proposition suggests that senators should automatically qualify for ministerial roles or the role of the chief minister. Indeed, I believe one positive outcome of the current arrangements is the electorate now can see a deputy, if the deputy were here, in the role of chief minister. The island and the economy hasn't collapsed as a result, not yet at least. The title of senator is just a title that reflects the bicameral parliamentary systems found in larger jurisdictions. And there is a reason why we have a single chamber in smaller jurisdictions, because we do need to right size whilst performing lots of different roles. It is for the State's Assembly to decide which of its members are fit to govern by whatever title they are called. The Assembly needs a decent pool of skill sets in this respect and should avoid creating barriers to inclusion. And ma'am, this is so important in terms of where we are going, in terms of our culture, our economy. Sorry, sir.
Yes. I thought for one puzzling moment you said, and man, then.
Ma'am, there was some...
Right.
A change of personality in the seat, sir. Sorry.
Yes, I must have sneaked back in when you weren't looking.
As for the State's Assembly, we need to overcome prejudice in all its forms. Some may think of bad examples of senators, while overlooking bad examples of constables or deputies. If States members choose to define a whole category of member by reference to the performance of an individual within that category, how can we ever hope to have an inclusive society? Some may suggest those who seek the office of senator are doing so in pursuit of ego or status. Some might equally say the same of anyone seeking a ministerial role or scrutiny chair. Should we not simply be valuing those who wish to be of service to the public? Sir, we also have reached a pivotal point in government's economic and financial management. The Fiscal Policy Panel has sounded warning bells, and we need states members with the skill sets that will assist improvements in these areas, rather than be overly reliant on unelected officers. We need balance. We need to accept what the Electoral Commission was saying, that much of our role is in the area of island-wide representation, island-wide duties, and that constituency representation is just not the predominant role. So a small jurisdiction like Jersey, with a relatively small economy, needs to attract human resources for its State's Assembly with consideration of its accessibility, and to organise those resources effectively with minimal duplication of activities. This is not to say that I don't believe there is a case for providing more support to members, including in constituency roles. if I could have a personal secretary so that I could respond to constituents quicker, I certainly could be more productive on that score, perhaps. As states members, most of us have a role in seeking the efficient and productive use of public funds. Some of us love constituency work, as do I. But we don't all need to be constituency representatives and to have the related support. We don't all need to be doing each other's jobs in any particular constituency. So despite what anybody might say, or be tempted to say, this proposition in seeking the reinstatement of senators, whilst retaining the constituencies and deputies, is far from being regressive. If states members choose to support this proposition, they can deliver positive progression in the areas of democratic representation, inclusivity, and resource management. I hope states members will exercise their democratic choice accordingly and support this proposition.
Is the proposition seconded?
Yes, sir.
There is an amendment to the proposition, and I ask the referee to read the amendment.
Page 2, paragraph B. Substitute the words "that will determine the number of deputies to form part of the" with the words "for a," and substitute subparagraph 3 with the following. 3. There should be 9 senators, reducing the number of deputies in each existing constituency by 1 and.
Deputy Farnham.
Thank you, sir. Having endured a number of debates on such matters in the past, I know that members will understand that this is an important and serious matter for our democracy. It will impact upon how islanders are represented in this assembly, sir, in the future, and should reflect how islanders want to be represented in this assembly in the future. This amendment is, if adopted, would establish a states assembly of 49 members consisting of 9 senators elected by island-wide mandate, 28 deputies elected under the existing constituencies, and of course the 12 parish constables. By way of some background, I wanted to remind members of the history behind the removal of the island-wide mandate, and I'll be as brief and as light as I can with it, sir, because it has been a long and hard day. And it's not really a great story. On 20th of January 2011, the Assembly voted to reduce the number of senators. There were 12 senators at that time, of whom 6 were elected every 3 years. The Assembly voted to reduce the number of senators to be elected at the next elections later that year, in October 2011, from 6 to 4, which with the existing senators made 10. So after the 2011 elections, we had 10 senators. At that time, sir, the Assembly also voted in favour of a further reduction from 10 to 8 senators for the elections in 2014. The process that led to this package of reform was instigated largely by a state's decision in 2010 to introduce a single election day. We put the cart before the horse at that time. The Assembly, in its wisdom, decided we would elect everybody on the same day. Not a bad idea, but actually, perhaps we should have agreed the composition of the States Assembly first before deciding how they were to be elected. Not long after that decision, sir, and after some head scratching, it was contended by some that it would be difficult, if not impossible, to elect all of the States Assembly, as constituted then, on one day. So the states agreed to reduce the number of senators again, sir, from 12 to 8 for the 2014 election, because it was felt that this was the maximum number of senators that could be elected on one day. Now, I think if we look back, at best we can say that was a naive decision, as other jurisdictions has shown us, not least in our sister island across the water in Guernsey, who managed to elect, sir, all of their states assembly by island-wide mandate, and I'm not commenting further than that at this stage, as they're having, I think, more challenges than even we are. It was the previous assembly, sir, to this, who agreed to remove senators altogether, meaning that by the time we reached the 2022 general election, the electorate had lost the right to elect members to this assembly by island-wide mandate. As members can see, the removal of the island-wide mandate was a protracted, in my opinion, rather arbitrary affair, taking more than a decade to achieve. An example of, I think, removal by stealth, because in the initial stages, after the reaction to a single true election day, it was never said at that time that senators would go altogether. But of course, we have seen that happen, so as we do. We often see a stealth at work in the Assembly. It was not properly thought through. It was not properly consulted upon with the people of Jersey by referendum or any other meaningful way, sir. And I know we did have a referendum where we were asked to consider three choices, option A, B and C. There were no, despite asking an amendment to ask this Assembly to put none of the above option in, that was rejected. And therefore we had three options, which a considerable number of members of the public didn't like any of them. I campaigned at the time, so with a number of other members, for option C, which was to retain senators, but it was for change, but not this change. And I think option B eventually won, but option A and option C had more votes than option B. So it just wasn't really appropriate. When previous assemblies, previous members, previous privilege and procedures committees did attempt to consult with the public, there was very little support. I remember having campaigned to retain the office of senator. For many years, I've attended many parish hall meetings. And in the last round of meetings in the 2018 or 19, I think it was probably 2019, when the previous PPC committee were trying to get this over the line, I attended a number of parish hall committees, packed parish halls in many instances, who were totally against the removal of the island-wide mandate. And there were some who weren't, so, but I would say 90% of the meetings I attended, parishioners, wanted to retain it. And that was not listened to, sir. And therefore all islanders who were entitled to vote have been significantly disenfranchised without the consent or their endorsement. When we tried to get a view, sir, it was ignored. In addition, there is no evidence from any debate that the Assembly at any time through the process of reforming of the composition of the Assembly, sir, has satisfied itself or even considered that the actions that were taken were not possibly contrary to the States of Jersey law, whose remit speaks of enhancing democracy, and I quote, sir, and whereas Jersey wishes to enhance and promote democratic, accountable and responsive governance in the island and implement fair, effective and efficient policies in accordance with the international principles of human rights. So I maintain, sir, that the states have taken a number of major constitutional decisions without due consideration, without appropriate public consultation, sir, and against the will of the majority. It is clear from public reaction during and post the last election that islanders wish to retain the island-wide mandate, and as Deputy Scott alluded to, so it was indeed a key finding of the Electoral Commission that islanders did want to retain that. And this resulted in a number of islanders, sir, choosing not to vote, leading to one of the poorest election turnouts in recent history. And this is particularly poignant, sir, as the new electoral system was predicated upon the objective of increasing voter participation and turnout. To that, sir, it failed. The office of senator was the most democratic of all the elected officers of states members and offered the greatest level of voter equity and accountability. in that senators are elected by and answerable to every voter and indeed every individual in the island. The senatorial elections provide islanders with an opportunity to discuss collectively and consider the key issues of interest to every person in Jersey, not just matters relevant to one parish or one district. And as members will remember, this was commented upon by very many voters and households at the time as we were all doing the rounds. There is a reason, sir, why we have three types of estates member, and that is, as again Deputy Scott alluded to, dating back to the reformation of this Assembly by the Royal Commission in 1947, sir, which led to the introduction of the senators. And that is, in Jersey, we don't have, we are a unicameral system. We have the State Assembly. We don't have an upper house. We don't have devolved assemblies. We don't have county councils, city councils, town councils. We have the State Assembly. We do everything here. We do a number of roles from which really affect and manage the whole of our island life. And we have three types of states members. We have our constable, because they represent our form of local government. And their very fact that they sit in this assembly, quite rightly in my opinion, is to give them input into the whole aspect of the political process. So we have deputies who represent constituencies that can be more focused on general political issues. And then, of course, to provide balance, we have senators who, as members will know, the holders of the senatorial office were extremely well placed to take unprejudiced and impartial views of issues affecting the whole island without being conflicted by parish or constituency pressures, thus providing an essential balance to this assembly. And I know a number of members that I've spoken to are having challenges and difficulties in balancing sometimes island-wide issues against what they may consider to be right for their particular district. The districts are relatively small in terms, even though they are larger, they would be construed now in previous terms as super constituencies, or they're sort of somewhere between what we had and the 6 constituencies that were proposed some time ago. And there are some very powerful lobby groups in those constituencies. And I know that some members find it difficult to deal with that and act in the best interests of the island. It's a difficult balance, and I think that's why we need an element of island-wide representation, because they can work without, in an unprejudiced way, without fear of retribution. So looking over their shoulder every 5 minutes because they want to keep their seats. The reinstatement of senators as proposed and the removal of one deputy from each district would have little impact on the greater voter equality when compared to the current electoral system. It would, however, give the electorate far greater voter choice and influence by increasing the number of representatives that each voter can elect by 8 members. So that's 1 less deputy, but 9 new senators. The loss of 1 vote, sir, are being replaced with 9 new votes. The island-wide mandate gives us all a shared, direct and equal influence over the makeup of the Assembly, and albeit more indirectly in the makeup of the government. And I concur with Deputy Scott when, although many members have commented that they would like to see the Chief Minister, some other senior ministers elected by island-wide mandate, I think that's not always necessary, although I would think it's far easier for the Chief Minister to be impartial. Again, we're not representing a district, and there are a lot more occasions where ministers and members have to declare interest or excuse themselves from decision-making because it affects their constituency. I think, sir, the reintroduction of the island-wide mandate is an important and a necessary step to help rebuild engagement and to help rebuild flagging confidence in our political system and our political structures. And as historic turnout figures have shown us, sir, it's not helped. The changes have not done anything to improve that engagement. And this is the opinion of many islanders, even sir, in the relatively short period of time since the last elections, that our democracy has been poorer without the island-wide mandate. The main proposition brought by Deputy Scott, whilst bringing greater flexibility, would, if approved, require significant further work to be undertaken by the Privileges and Procedures Committee, which would be challenging to complete in the absence of any consensus, really, among members. And we know, we've discussed this at PPC, we've discussed it amongst ourselves. There is a wide range of views, and when there is a wide range of views, we never usually end up with the right compromise, and we have, I think, now a compromise that is not working in the best interest of representing islanders, because I think we now have an imbalance in here without the island-wide mandate, given, sir, and I'm sorry to repeat it, that we are a unicameral system. Also, sir, in discussion with a number of colleagues about this, while supportive of the principle of Senator, a number of members wanted to have some detail around what was being voted for, and that's why I brought the amendment to this. So actually we knew what we were going to be voting for, what we were going to be getting, rather than put it back into the hands of the Privileges and Procedures Committee, I think, which would create, I'm not saying it would be impossible, but it would be, I think, very challenging to come up with a position that we could all agree upon. And with that, sir, firmly in mind, this amendment provides the specific solution with ample time to achieve implementation in line with the wording in the proposition, sir, which is to get the legislation ready by mid-2025, ready for the 2026 elections. So I'm pleased to make this proposition and present it for debate, sir. Thank you.
Is the amendment seconded?
Yes, sir.
Does anyone wish? Well, yes, we do. We have Conor St John.
Thank you, sir. It appears like déjà vu. I haven't been in the Assembly very long, but debated this a number of times and listened to many more debates on the radio. So before the debate, the scheduled date of the debate, I spoke to 3 people who I trust and value their views. I asked them for their views. The first one's view was that the new system was working much better than they had expected. The second view was, it doesn't matter what you call people, it doesn't matter how you elect them, what really matters is what they, or should I say we, do. The third person thought we should have 37 island-wide members and 12 constables. So if I'd asked 50 people, I could have got as many as 50 answers. As I mentioned in the last debate on this subject, yes, in St John, the topic of island-wide representation was raised many times on the doors. Whilst it was a topic raised by many, it paled into insignificance compared to other subjects such as the hospital, health service, road safety, especially speeding vehicles, and housing for both young and old, to name just a few. Of the many people who said they wouldn't vote because they weren't senators, how many of those would have normally voted? How many actually voted? Let's look at the numbers. In 2018, 43.3% people voted, 26,947 out of an eligible 62,153. In 2022, 41.6% of people voted, 25,200 of the electorate, with 60,678 people registered to vote. What's more concerning to me is the decline in the amount of people registered to vote. And was that COVID? Was it a reduction in the population? Was it the loss of senators? Or was it a combination of all 3 and/or other things? What impact does our antiquated polling stations have? How many more people will vote if we make it easier for people to vote anywhere, and if we made polling stations easier to access, the obvious choice being the Good Companions Club in St Clement? I've written on this subject before, sir. There are many, many more convenient places. And why don't we try and hold elections on a Sunday if we want to increase voter turnout? And before people say we won't get the volunteers necessary, look around you. See how many countries do this. Those people working Monday to Friday who can't volunteer, they would love to volunteer and get involved. It may also help with the very workers that Deputy Scott referred to in her opening, and I'll come back to that. Sir, I'd like to remind members that Islanders were given an option to retain senators in the referendum 10 years ago, and they roundly rejected that opportunity. Sir, it took 9 years and importantly 2 election cycles to actually implement the result of that referendum. New members may ask themselves why. Well, it took 9 years due to very well-intentioned propositions and amendments similar to today's that kept blocking the change. Sir, whilst I'm sure colleagues opposite me won't agree with me about the outcome of that referendum, I'm sure that they will agree with me that the wishes of the public, whatever they were, should have been implemented much sooner. Have we really given this system time to bed in? Are the people who aren't happy not happy with the fact we don't have senators, or are they not happy with ministerial government? To be clear, sir, despite recent events, I'm not suggesting we return to the committee system. Sir, back in January, I suggested that we needed to give the new system time to settle in, and my position hasn't changed. Why not look at some of the positives? I remind members that following the last election, we have our most diverse assembly to date, something that we should all celebrate. The chair of PPC told us in the last debate on this subject that we need to do more to engage at grassroots. Well, sir, I couldn't agree more. I think there's been some progress in this, albeit we have all got some way to go. The feedback from parishioners and others who have attended the deputy surgeries at St John are generally very appreciative of having the opportunity to speak to up to 4 representatives rather than just the one they had in the past. The Council of Ministers have invested time in meeting the public as they travel around the island. So at St John, almost 50 parishioners, they were queuing out the door because we're engaged. They turned up to speak to members about a whole range of subjects. More recently, the Committee de Connétable had a meeting in St Mary's where around 40 islanders turned up to listen to the Environment Minister speak to the Committee de Connétable. Sir, those are examples of good public engagement, and we have to do more. Deputy Scott spoke about everyone having roles. Well, sir, I've been looking at where I may offer my services during today's sitting, and I'm shocked at how many people are on just one or no scrutiny panels currently. Deputy Scott spoke about the migrant community. Well, sir, I can tell her that in 1994, I had manifestos translated, and I held a hustings meeting for my candidate in a farm shed one evening with a translator. That candidate won a very close election, and it was those farm workers who turned out to vote that actually made the difference. There's nothing new. Deputy Scott spoke about affordability. Well, again, sir, in my experience, was fairly extensive. It is much more expensive to get elected on an island-wide mandate, albeit people like the former Senator Sivray and others have proved to be exceptions to the rule. In fact, sir, in the Guernsey election, I helped somebody get elected all island for less than £500.
Can I just interject a moment, Connétable? The debate is, of course, of whether or not to accept the amendment. It's not on the main...
It's about senators, sir.
Well, no, it's about whether we accept Deputy Farnham's amendment to Deputy Scott's proposition.
Okay, sir.
It's not the main debate about senators or not. It's whether the amendment should be accepted.
Okay, sir. Well, I shall speed on then. Sir, as I did in January, I'd remind members that under 20% of people voted to retain senators in the 2013 referendum. Yet it was this assembly that rejected the views of 80% of the people that took part. I'll take people back to those elections in 2014 and 18. I worked on campaigns in both those elections, sir, and I can tell you there was lots more disappointment than this time round. The public were angry. They were angry and disappointed because their voice had simply been ignored. So I can't help but think that Deputy Farnham would take us back to Durets and rectors if he had his way. PPC tell us again in their comments about allowing time to bed things in. I would respectfully suggest that we should allow at least one term, if not two. If we do not move forwards, let us stand still, but please do not move backwards. Thank you, sir.
Deputy Tadier.
Thank you, sir. I will speak to the amendment insofar as I want to save my comments for senators and whether we should bring them back or not for the main debate. Notwithstanding the previous comments, I think they were well made, and it's good to hear the Constable of St John, who speaks so much sense. I'm sure that many members agree with that, and his talents, I'm sure, will be appreciated on the scrutiny benches, and I'm sure even perhaps on Deputy Scott's panel. I think she's still looking. So, and I know the value of scrutiny, having taken part in the one on the immigrant workers and work permit holders, so that there's lots of work to be done on scrutiny as well as in government, I'm sure, sir. So I look at this in a very the amendment in a very clear way. Is the proposition better with the amendment or better without it? And I think it's better without it for a couple of compelling reasons, which we don't even need to get into whether you're for or against senators. I think the way Deputy Scott has crafted this with, I think, some very well made arguments in her opening speech are the fact that it leaves still some work for PPC to come back with. They can look at different options, they can consult with the public and find out what the best way to reintroduce senators would be. And it may not be simply to introduce 9 senators, because that simply seems like a convenient number. It is nonetheless an arbitrary number. It's one thing to say, take one deputy from each district. But of course, that will have, I think, definite mathematical consequences for the populations of the island. I would call them unintended consequences, but I also think they may be the intended consequences. So, for example, if we look at St Saviour, and I know we have currently 6 representatives of St Saviour in the Assembly, we've got 1 constable and 5 deputies, and according to the 2021 census, there were just under 14,000 people living in St Saviour. That may have gone up slightly. They're a couple of years old now. And they've got 6 representatives. But if we look at the constituency of St John, St Lawrence and Trinity, including their constables, they've actually got 7 representatives in the Assembly. They have 3 constables and they have 4 deputies. Now, the issue we've got there, of course, is that St John's, St Lawrence and Trinity have a smaller population than St Saviour. So that area, that geographical area, all those voters collectively already have superior voting power in this current reformed assembly than St Saviour has. Now, is it acceptable to take already an unfair system and make it even less fair with this amendment? Because what would happen is that by removing a deputy from each district to create this new role of 9 senators, we've never had 9 senators before, incidentally. We've had 12, we've had 8, we've had 4, and we've had elections where you can vote for 6 and then you can vote for another 6, but we've never done 9. Is that a good enough reason to create an exacerbated unfairness between potentially town and country that we've tried to resolve? So what would the scenario be for St Saviour? St Saviour loses a deputy so that you can have a new senatorial position. Why? Don't know, but that's an argument for the future. So St Saviour now has 4 plus 1, which is 5, 4 deputies and 1 constable. But of course, St John, St Lawrence and Trinity only have to give up 1 deputy, so they still get 3 deputies and 3 constables. So the unfairness is now 6 to 5. But St Saviour's has still got the bigger population, but they've got fewer representatives proportionally in the Assembly to make way for an island-wide mandate, which, in my opinion, solves nothing. Now, I don't think that's necessarily, for me, that's a great concern, because I think we've made great steps towards increased fairness. Nobody currently is looking across the chamber and saying, what are you constables doing in here? You represent some very big parishes and some of you represent very small parishes. I think that what we've seen is a compromise position where we've taken on board the importance of tradition, of the parish voice, and of fairness, and we've seen an increase in there. And I think at the moment we've got a very fine balance of acceptability between traditionalism and between what some might call mathematical exactitude, but others just call voting rights, fair voting rights. And I'd be loath to throw that out, given the fact that we've spent so much time getting to that very finely balanced position, which I think is certainly a good position to be in. But the other point is that if you are going to have senators, and let's entertain the idea that maybe senators should be brought back, should they not be brought back perhaps like in the olden days when you used to have 6 and 6, and that actually you have 6 senators that you elect for, let's say, a 6-year period. It could be 5, it could be 7, whatever. And actually that those people, because the point that Deputy Farnham made is that you don't want a group of individuals looking to the next election, therefore being scared to make tough decisions. Now, that argument doesn't follow if senators also have the same election cycles as deputies and constables, because they will be looking to the electorate. They just have a bigger constituency, right? So if it's important for us to keep in touch with our constituents, which I hope it is, whether you're a constable or a deputy for a parish or a super constituency, it's really important that you have that interaction with parishioners to make sure, if nothing else, that you're grounded. You know, and I think that's personally why I think it's really important to have a constituency you're attached to. But if you're a senator, you don't stop having the constituency work. You don't stop having the constituents that you need to please for the next election. And there's a risk that actually it might make you more populist on an island-wide basis if you're facing the same election with everybody else. Surely, those of you who support senators being back in the Assembly might want to make the point and say to PPC, we want senators, but we don't want 9 of them. We want 6 and 6, like in the old days when the system used to work well, and then you can have an interregnum, if I can call that, during the election, where you can have that stability and that continuity, if that's your thing, if that's what members think. It may well be that actually you think we should have 1 senator. That'd be a great idea, wouldn't it? Just have 1 senator, elect them at the same time as everyone else. The stakes become really high then, because there's an implication, isn't there? You need to become senator to become chief minister. It's not going to be a given thing, but if you've got that island-wide mandate and you've seen off 5 or 6 other chief minister candidates, when you get to the Assembly, you'll have surely had a great island-wide mandate behind you to put yourself forward for chief minister, or maybe you'll be happy just being the chair of the Scrutiny Liaison Committee. Who knows? So I think, purely speaking to the amendment, sir, I think actually I wouldn't want to tie the hands of PPC going forward and say that actually, if this Assembly is going to undo all that work that we've made and impose senators back on the new Assembly, we at least want to make sure that we've explored all the options to make sure it works. But I go back to the point of fairness. If we do adopt this amendment, it becomes inherently less fair in terms of the mathematics. And fairness is important not just purely for the democratic exercise and the mathematics to stack up. If we look what the corollary of fairness is that it has produced a more diverse Assembly. Now, I caveat that with the fact that we shouldn't always link correlation and causation, but I firmly believe that actually, if you look at the statistics throughout the history of elections, what's the maximum number of female senators that we've ever had in the Assembly? It's always been a minority. I can remember maybe 2 or 3 maximum, and I don't even think that they've all served at the same time. I can remember having 3 female constables at one time in this Assembly, and that was considered a good batting average. But we've gone from a point where actually it's much easier when you have large constituencies where you get the best marriage, I think, between, and I know I'm veering into the next debate, sir, but it is important to show why adopting an unfair amendment could also potentially undo that great work that we've had, where actually you get a much more diverse Assembly. Not just women, incidentally. Look at the languages that are represented in this Assembly. We've never had that before either, where we get people speaking in their second or third languages very fluently, very coherently, making great propositions, contributing to the political debate. So by all means, you know, I hope that this speech isn't lost overnight. By all means, reserve your position on whether you want senators back. We can make the arguments for and against that tomorrow, but please don't accept this amendment, because I think it does unnecessarily tie our hands to a flawed and unfair amendment that we don't need to accept.
Could I propose the adjournment, please?
Yes, I can tell people I have at least 3 other people who wish to speak. That time has come. The adjournment is proposed. Very well. The Assembly stands adjourned until 9:30 tomorrow.